All right, as you can see, we're having some technical difficulties, but while we work those out, we'll go ahead and get started. Thank you everyone for being here. I hope everyone's, rest of the summer was pleasant. We'll go around the room per usual with introductions. We'll start here in Schenectady. I'm Clarissa Rodriguez, Chair of New York State Workers' Comp Board.
I'm Michelle Cummings, the facilitator of this group.
I'm Lev Ginsberg with the Business Council of New York State.
Matthew Mead from Stockton, Barker, and Mead.
Meredith Woods, Workers' Comp Board.
George Stollis, Workers' Comp.
David Wertheim, Workers' Comp.
Joe Nolte, New York State Insurance Fund.
Justin Teff, Kirk and Teff.
Lindsay Roller, New York City Law Department.
Okay, and Steve Smith.
Steve Smith, Workers' Comp Board.
All right, and I'm sorry? Oh, yeah.
I'm Robert Goldberg, Medical Society, State of New York in Harlem.
Joe Cannabis, New York State AFL-CIO.
Thank you. And in White Plains, we're still waiting, and I know Brian Trigg from Wegmans cannot join us today. So we will go ahead and get started while we wait for White Plains to join. So. Okay, so.
All right, so this is our September meeting where we're going to talk about fraud abuse, review the questionnaire responses, and discuss the initial draft report. And today we will hear from the Office of the Inspector General on fraud and abuse and review and discuss your questionnaire responses and the draft of the final recommendations. At our session in October, we will present and review another revision of the recommendations report, including your responses. Today's agenda will address the topic of IME fraud and abuse, and we welcome Audrey Cunningham, Deputy Inspector General for Workers' Compensation Fraud, from the Office of the New York State Inspector General, who will provide us with an understanding of the potential crimes they encounter, like altering IME reports, falsifying applications for registration, or willfully disclosing claimant information, and how they address these issues. We are going to modify the schedule slightly. The presentation and discussion from the Fraud Inspector General will be about 20 minutes, and we are not going to take a break and see if we can just get through the agenda because I think the rest of the things will probably take longer. So at this point, I'd like to turn everything over to Audrey Cunningham.
Good morning.
Is it okay now?
Yep.
Yes, it looks like White Plain has joined us. Yes, we can see you now. Thank you.
Thank you.
All
right, so I would like to turn.
It looks like there are no committee members that have joined us yet, right?
No, there's not on White Plains.
All right, thank you.
I'd like to turn things over to Audrey Cunningham from the Office of Fraud Inspector General. As she is going through her presentation, please hold your questions until the presentation has ended, and you will have plenty of opportunity for questions then. Audrey?
Great, thank you. Shall I stand, sit?
Sit, you're probably more
Okay.
comfortable.
Great. Thank you for having me. I am the Deputy Inspector General for Workers' Compensation Fraud with the Office of the Inspector General. So I wanted to really just briefly give a brief overview of who we are, what we do, the types of cases that we handle, the investigations, and focus a little bit on some of the provider fraud that we've seen in the past.
Sorry, Audrey. Could you mute?
Yeah, can everyone just mute themselves? Hi, Dr. Qua, how are you?
Hi, how are you?
Good, good. If you don't mind muting yourself, thank you.
Sure.
Okay, great. So we are the offices of the Inspector General. Many of you know us, know the Office of the Inspector General in terms of our original jurisdiction, which is any fraud and abuse within state agencies. So it's any state employee who's committing fraud and anybody that contracts with the state. That's sort of our traditional IG role. But the other side of our house is the Workers' Comp Fraud Inspector General, and our jurisdiction is actually a little bit broader than the Inspector General's jurisdiction in that it's not just related to state employees. So we derive our jurisdiction from Section 136 of the Workers' Compensation Law, and that is essentially anybody who is complicit in committing fraud within the workers' compensation system. So whether you're a state employee, whether it is a treating physician, an IME provider, an employer, such that the employers aren't carrying the appropriate workers' compensation insurance. So it's anybody that's complicit. So the jurisdiction is quite large. And we have offices all over the state. Our hub is here in Albany. We have a New York City office, an office out in the Western region in Buffalo, an office in Syracuse, as well as a satellite office down in Hauppauge, outside of New York City. And our folks they run the gamut. So we have investigators, attorneys, auditors. We're very fortunate to have an investigative nurse on staff, particularly for the provider cases. A lot of former law enforcement folks. Many of our attorneys are former prosecutors. I myself am a former prosecutor. So that's sort of kind of who we are. Now, we have a case management unit, and that's where it's a little bit of the hub of the office. That's where we get all of our complaints, and particularly on the workers' compensation side of the house, we generate a number of complaints. We get complaints from all over. It can be, the disgruntled neighbor. We get complaints from insurance carriers, administrative law judges. It runs the gamut. And we take those complaints very seriously, so much so that this past year in 2018, we had a dedicated triage unit just for workers' compensation to go through each and every one of those complaints. I personally go through the complaints, the Inspector General herself. We conduct preliminary investigations of all the complaints that come in the triage unit, and then we take it from there. So that's our triage unit. Last year, 2018, just briefly, we had a big year last year. We had 34 arrests, over 1,800 complaints, and we uncovered close to $9 million in fraud. And again, that covers the gamut. So I know we're here. I want to focus on the providers, but we focus on the various areas, and I like to call it sort of three buckets of fraud that we see across the gamut. And the first one being, on the provider side, that is not just the treating physicians or the IMEs. That can be anybody within a particular treating physician's office. So if somebody is complicit in the fraud, we have jurisdiction to look at them. So for example, on the provider side, we have 2 out of the arrests that we had in 2018 were providers. Those are typically our longer-term investigations. But some of the things that you might see are physicians who are obviously billing for services that were never rendered. Providing false notes to claimants to keep them out of work, things of that nature. Billing, you can't really be in 2 places at once. We've seen some of that. So that's sort of, kind of the generalities. You touched on application fraud, anything to the extent that if there's a provider that is misrepresenting on an application to be an IME provider, that is something certainly, if someone's lying about their credentials, and that goes, again, that runs the gamut in terms of not just for providers, but also for employers and the like. So that's sort of very kind of general in terms of providers. In terms of employers, we look at employers to the extent that, and that runs the gamut. That's anything from businesses who are not maintaining a workers' compensation coverage and somebody gets hurt. We see a lot of crossover with labor law violations and employers underreporting their payroll, particularly in the riskier businesses of construction, more so in the New York City area. We see a lot more of that. So it's important because it undercuts the legitimate employers who are providing and paying for workers' compensation, and then we've got employers who are, who are not doing that. And then if you've got an injured worker on top of it, so those are the type of employer fraud that we look at. Now, we do not prosecute our own cases. We investigate our cases sort of soup to nuts, and then if there is something that is criminal in nature, we do refer that on to criminal prosecutors, whether that's the local prosecutors, federal prosecutors, whoever is appropriate. So we put something together and send it on for prosecution. And that's, the outcomes vary. So if we're talking about a provider, in the last 2 cases that we had, the prosecutor had a heavy hand, and part of the resolution was that the particular provider relinquish his license to practice. So those are, just some of the things. If it's something related to a claimant, that, potentially be restitution, but there are, different results that you can see once a prosecutor gets the case. And really, for your purposes, if there is some sort of fraud that you are seeing, that you believe you're seeing, no matter what it is, please, refer it on to our office. You can pick up the phone and call me. You can do an anonymous complaint online. There are, many ways that you can report something. So if, I like to say, if you see something, say something. So that's, again, a very sort of general overview of who we are and what we do.
I think with regards to,
Are there questions actually for Audrey, since she is here
I have a
on the
couple.
process?
Real quick, thanks, Art. So there were 34 arrests last year, 1,800 complaints. Is there any breakdown as to sort of, you mentioned that 2 of the arrests were doctors or people who were medical providers. I'm imagining that IME doctors would be folded into that too, or are they a separate entity? I'm trying to get an idea of what the numbers are.
Sure. Yeah. So for 2018, for the numbers that I gave you, the breakdown was 6% were providers, 44 were employers, and I believe 50 were claimants. So IME providers are not treated any differently than, say, a treating physician or another type of provider, whether it's a chiropractor or otherwise. So, we look at everybody in the same way. So whether you're an IME or a treating physician, if fraud is being committed, you're going to be looked at.
Sure. And then my second question is, I don't really know how to put this. There's 1,800 complaints, and you just mentioned you can complain online, for instance, anonymously. So out of 1,800, a certain percentage of them are gripes rather than, sort of real bona fide complaints, I would imagine. Is that 1,800 total, or is that 1,800 valid complaints? I don't know any other way to.
So it's 1,800 that have come into the office. So,
Okay.
yeah. Whether it's, and we look at everything, so it may be that something is looked at and it is sent to the insurance carrier or sent to another entity that is more appropriate to handle it.
And so ballpark out of 1,800, like half of them maybe are easily resolved, or, I'm just sort of trying to get an
I think he's
idea.
trying to get a sense of the scope of.
Right, so, we had 34 arrests, so those are the cases that actually came to fruition in 2018
Sure.
that actually led to an arrest. That doesn't mean that there were only 34 live,
Right.
ongoing investigations.
For sure.
Because particularly on the provider side, like I said, those are, longer term, more in-depth investigations that oftentimes it does take, a little bit of time for the investigations to come to fruition. And then it's with the prosecutor, so we have control over what happens at that point.
Thanks.
Does that help?
Yeah.
I have a question. Do you know whether any of the 6% of complaints that came in against providers were based on altering a medical report?
So the 6%, the provider cases that we had, those are the 2 matters that fall in that 6%. Those were, and I can talk about them because they have since been resolved.
Okay.
Those were, one was a rare case that we don't see very often. It was a physician who was actually, he was on his way to jail after committing some workers' comp related fraud. and he had been convicted. We were not involved in the prior case. And what he did prior to going in was he assumed the identity of another physician and began billing.
I know who that is. I know who that is.
So that was one of them, yes.
Okay.
And the other one involved a physician who was billing for services that he did not provide. So that was the two places.
Was he an IME physician or a treating physician?
He was a treating physician.
Now, those were the two arrests. Any idea, I think you said 6% of the complaints were against providers generally?
No, and the 6%, so I just did the breakdown amongst the arrests. So the 6% was, the 6% were provider-related arrests out of the 34.
Are you able to speak to what generally, only because the focus really is on the IMEs,
Sure.
What generally the complaints are, be they, as Liv said, gripes against the exam or the opinion itself, versus what you thought were valid complaints worthy of further investigation, obviously without getting into too many details?
So I'm not sure I understand your address.
So obviously complaints are filed against physicians.
Mm-hmm.
I'm guessing there were more than two. What's the level of validity? What types of complaints are you finding you're getting against IMEs, and the general validity of what those complaints are, just to focus? Sorry.
So I mean, the complaints really run the gamut in terms of, so I can't get into sort of the nature of our investigations.
Sure, of course.
But I guess what I want all, because I know that you're all sort of coming from different viewpoints. If there is an allegation of fraud, whether it's against an IME provider, a treating physician, an employer, what have you, it's looked at in the same manner.
Okay. Now, can you speak hypothetically to some complaints that are levied against IMEs, not with reference to any particular case or matter, but just to generally inform the group? If there's a complaint about an IME, what is being complained about?
I mean, I think that the with respect to IMEs and treating physicians, it would be, service, maybe services not rendered, someone else is doing the exam, things of that nature.
Okay.
I know I think that billing is also something that, with respect to what we've seen in the past, the cases that I referred to, it's, what is this particular physician billing, and has there been some sort of a theft of services in that way?
And are you distinguishing as between IMEs in particular and treating doctors, or when you speak of providers, are we kind of lumping them in together?
I'm putting them together. Again, it's they're going to be looked at in the same way. It's not like, oh, IMEs are here and treating physicians are here. If there's an allegation of fraud, or if someone is overbilling or not seeing a patient, or doing something nefarious, or altering a form, certainly altering a form, if there is proof that a form is being altered or the treatment wasn't rendered, again, whether that's a treating physician or an IME, if it's a fraud, the prosecutor is not going to distinguish between the type of doctor or the type of exam.
I guess I think it sounds to me what everybody's trying to get at is, do you keep metrics on this sort of thing? In other words, how many were in complaints against, injured worker, against IMEs, against treating doctors, against insurance companies, against employers? Do you keep metrics on that information?
We do. I don't have you want the metrics out of the 1,800 complaints. The metric, how many complaints came in with respect to
how many had any needed serious, follow-up, and of those, what were the variety, who were they against, and what was the nature of those complaints?
Right. So what I can talk to that's not sort of going into any confidential investigation are the things that have come to fruition and are now public. So I can't kind of get into, the ongoing.
No, but I meant
But
in
even
terms of
numerically
generally,
speaking.
numbers generally, you guys don't track that kind of thing?
No, we do, we do track them. I don't have the number that I think you're looking for, which is how many complaints against each entity.
And what were the nature of those complaints?
I think what she's trying to get at is to the extent that this group is charged with looking at the IME process, what is it you see from your perspective, or can you provide insight on as to IG complaints?
Right, so I think that the insight, or what, I would want to get across is, if there is any kind of misrepresentation, whether it's, on an application, whether it's on a report, if that's a misrepresentation and that's being submitted and a physician is getting paid for it, that's a potential fraud. That would be an example. And again, that doesn't distinguish between IME and treating physician.
Mm-hmm.
That can happen on either side.
And I guess for your purposes, you don't necessarily distinguish about, provider type. It's a provider, so you don't necessarily distinguish treating versus IME. We are looking at IMEs in
Right.
particular in this one committee, so I think, that's why we're asking all the questions about what complaints have you seen. Is there anything that you have seen that's maybe like an emerging trend that you can discuss, that's maybe a little troubling you want to flag for us, since we are looking at the IME process with regards to provider fraud?
Not that I can really discuss.
Okay.
no.
Yeah, no, that's, if it's under investigation, we get, yeah.
Do you investigate complaints about other vendors in the system?
Absolutely. If there's a vendor in the system who is anybody that is complicit in the fraud, if there is a vendor who is aiding or assisting, with knowledge or without in a fraud, that is certainly something that we can look at.
So to follow up on that, have there been any IME vendors that are under investigation or complaints filed against them?
That I would not be able to share with you.
Can you tell us whether the 2 arrests of providers were the only 2 complaints against providers in 2018?
Those were not the only 2. Yes. Those are the only 2 that ended in an arrest in the year 2018.
So they may
Okay.
have been the result of complaints that came in 2017 or 2016 or 2015. correct?
Yes. And in fact, they probably did come in a little bit earlier, because by the time a complaint is investigated and then sent on to a prosecutor and arrest, it wouldn't necessarily
Take some time.
Yeah. take some time. Yep.
Of the 3 examples that you gave that would be a provider fraud, if you would, you mentioned services not rendered, someone else doing the exam, or billing fraud.
Mm-hmm.
Do you have a sense out of those 3 sort of what's most prominent? Because at least from my vantage point, I'm thinking that services not rendered and billing would not really be something I think that we would associate with IME providers in any way compared to how you would with a treating physician. Perhaps someone else doing the exam or filling out the form would be an issue. So I'm just, out of those 3, just sort of some idea of like what's more prevalent of those 3, or most or least.
Probably the most prevalent would be the billing fraud. But to the extent that hypothetically, if an IME, if there's an IME office and there's a provider who's not authorized to conduct IMEs, and that provider is conducting the IMEs, and somebody else is signing off on it, something like that would certainly fall under the realm of potential fraud. So.
Sure.
I'm not sure if this is something that the fraud and abuse can actually be addressed easily, but my biggest concern, I think most people on this board are concerned with a doctor who does 100, 200, 300 IME exams and finds all the people are not really injured, they're faking, and is not giving a really appropriate exam and findings, but is biased based on who's paying him. And I don't know if this falls under IME fraud and abuse, or it's just a guy who's not being reputable as a physician. So you can't really report, there's one doctor in Westchester who does this all the time and everyone is fine, even though I've treated some of the people that he's done the IMEs on, and I know his reports are not truthful. It's not something you can really describe as fraud and abuse because you can't prove that his exam is false. So I understand that it's easy to prove someone's having someone else do an exam, someone is billing incorrectly, someone is doing something that's obvious like that. But my real concern, and part of the thing that I think we need to reach a consensus on, is how to stop the doctors who are really not doing a fair, good job. And I'm not sure if this is addressed in the fraud and abuse that we're talking about.
I'm not saying this should or should not be. It's part of, I guess, later in this meeting. If all the IMEs were videotape recorded and made available, would that be of any assistance in what you're discussing, or not so much?
I don't think that would be helpful, but I think if we took 100 exams from one of the doctors and they were all, no one was found to have anything wrong with them, there's something going on.
Does the board have any mechanism wherein it tends to review not just the four corners of it, but the substance of the IME?
Yeah, when we get complaints, we do look at them. We'll look at the report. I know the medical director's office will look at the report. She'll often look at videos to see if things match up together with the Office of General Counsel, and we'll figure out what the next steps. But yeah, they do that regularly.
Does anybody else have any questions for Audrey? All right, thank you, Audrey, for taking the time to share with us today.
Thank
You'll
you.
discuss the
Thank you so
information
much.
and determine if there are recommendations for combating fraud and abuse beyond what OFIG is currently doing. Thank you.
Thank you.
Okay, what we gotta do? All right, having heard from Audrey, are there issues that the committee would like to discuss as a follow-up to that, our presentation?
I mean, for what it's worth, it sounds like it's a relatively minuscule number of fraud complaints and arrests that are IME associated. I mean, 6% are providers, and, you know, a fraction of that at most are probably IMEs. It seems like a topic that we probably need not touch, especially since the Inspector General's office seems to have those rare cases well in hand, and I just don't see a point.
Does anybody else want to make any comments?
Yeah, I think that, you know, the understanding the role of the IG's office, we're pretty limited in the amount of information we could get from this appearance. So I think that to surmise that based on the number of arrests, like extrapolating the prevalence of the problem from the number of arrests is faulty at best. I would say irresponsible.
Okay.
I don't think that it's something that we should discount. You know, there were, and like I said, understanding the role and understanding the need for it, there are a lot of non-answers there.
And the problem, of course, is qualifying the data of the complaints, which we can't do. And really the only topic that was brought up that could possibly be an issue, which we've already addressed, is if someone else were doing the exam, or if someone else was filling out the exam. I mean, we've already been over those topics, you know, as a committee, so I'm not sure, you know,
or if someone is totally biased in their results.
That's
you know,
opinion,
the
that's
other
not
thing
fraud,
is,
Joe.
listen, we have 200,000 cases a year, I think we heard, in the workers' comp system. To suggest that only 32 or 34 out of 200,000 involve fraud, I think is laughable. You know, I think that you also have to consider the limited resources of the IG's office, the limited resources of the prosecutor's offices. We didn't hear about how many referrals they had. I think that 1,800 complaints is a significant number of complaints. How many
than
players in the
1%
system?
total.
How many players in the system know what the IG's office is, have access to them? I've never made a complaint to the IG's office. However, I have seen troubling things going on in the system. So, just to say that the number of arrests correlates to the size of the problem, I think is inaccurate.
To your point, I mean, there's 200,000 cases, 1,800 complaints, it's less than 1%, right? Of those 1,800 complaints, let's say 10% of them are to providers, right? So we're at 0.01%, and then from those, the IME is 0.001%. I get your point, I know we don't know everything, but we're gonna be looking for needles in a haystack here and wasting a lot of time doing it.
I'd like to follow up, that's 200,000 IMEs, not injured worker or injured worker visits or treatments. That's in the millions. And we're talking about 34 that were referred for investigation. That's a real small number. It's not 200,000, it's millions.
So add a couple of zeros after the decimal point.
Yep, and before it for your result.
Do we have any actionable information? Anything we can act upon to describe, to come up with a recommendation?
Well, I'll offer this. David, I'm going to look to you for a second. Would it be helpful to talk about our internal process when we get these complaints and what we do, so that maybe, to inform the conversation a little bit?
Sure. The board does have jurisdiction over the providers that are authorized by the board, and when there are complaints, they are investigated, and if there is misconduct or potential misconduct, the board can take administrative action. If something looks like it's potentially criminal, it should be referred to the Inspector General. If something is otherwise, again, potentially misconduct, it's something that we do investigate, have that authority under the workers' compensation law, and we do investigations.
How many, or how frequently does the board make a referral to the Inspector General?
It's not, I don't have a data point for you on that, but there are direct referrals to the Inspector General by anybody in the system, including our administrative law judges, the workers' comp board itself, the panel members, any employee of the board can make a direct referral. So it's not as if the direct referrals have to flow through the Office of General Counsel. But if we're doing an investigation and something looks like it could bear upon a potential criminal investigation, of course, we do refer that over.
So maybe part of the problem here is that the complaints, I'm guessing, that even the board gets are isolated in their scope. I'm guessing the board is not getting complaints that I read 1,000 IMEs and they all say the same thing, because who would be able to make such a complaint? But if that's really the guts of what the problem seems to be, and I don't, I'm just going to pick numbers here, but is there a potential recommendation that the board could take a more affirmative stance or review with any particular number? So if you're going to do 300 IMEs in a year, fine, but if you're going to do 5,000, the board is going to actively look somehow at your 5,000, and you know what, if they all reach the same conclusion, there may be a discussion to be had. Again, I'm willing to admit some of it is certainly professional, but I think if I was able to glean, that was really the guts of what was being suggested there. Who's going to rein in the people that do 1,000 and always find no disability?
I agree 100%. I think that's a big topic that we should attack and deal with as a board, because that's where a lot of fraud and abuse really is.
Do we have any data that tells us that that actually happens? Like, for instance, I know that there are providers that are doing 1,000, maybe a couple more than 1,000, and whether that's problematic or not, I'm not passing judgment on. But do we have anything that indicates that of those 1,000 of them are finding no disability or exceptionally low disability? I mean, we haven't seen anything that indicates that, just that they've done a lot, or am I mistaken?
That I would think, and respectfully, of course, probably comes more from seeing the everyday practice of it when you're down in the trenches, seeing this doctor and this name, and expecting more or less what you're going to see in that IME just by the name. I could not give you anything other than, nothing empirical, just I'm forgetting the word now, but,
Anecdotal.
thank you. That is the only thing, but I would hesitate to back off so far as to say that does not happen, because anyone that does practice day-to-day, we know those names, and we know the names of the people that you see it, and you're like, oh, good, I'm gonna get a real honest, terrific opinion here, and maybe I'm not gonna like it, but boy, this doctor's good. But then there are other names I see where I know it's no disability, no further need for treatment, never has been, never will be, and they're still doing IMEs.
David, is there any restriction on who can make a complaint to the board about a provider?
No, none whatsoever.
So a lawyer could make a complaint, another
Yes.
physician could make a complaint?
And we get those complaints.
Okay. And the investigation of the complaint, I presume, would include might include looking at a broad sample of the reports or the activities of the provider being complained about, right?
It absolutely could, but also keep in mind, we're, counsel's office, we're lawyers. So the role of the medical director's office is also very, very important here. So if anybody's asserting that somebody is not following proper medical protocols, that despite objective findings, they're ignoring them, there could be a legal problem with that develops. It could be a pattern that's problematic. Somebody may not be following medical treatment guidelines, or whatever the case may be. But the medical director's office is extremely important in this process as well.
Right, and the medical director's office has the authority to suspend or revoke authorizations to both treat injured workers and provide, perform IMEs?
No, it's the chair has the authority.
The chair has that authority, okay.
I'd like to bring something up. Years ago, every progress note was handwritten. Now we rely on electronic medical records, and there are some vendors, particularly for physical medicine rehabilitation or chiropractic or physical therapy, that generate an identical progress note. So one could have a patient being treated for 50 or 55 times, and that note is indistinguishable. And I challenge myself to try to find the difference between an April treatment or perhaps an October treatment. So we're talking about using the same thing over and over again. I believe that a large blame in that process goes back to the electronic medical record, so much so that Medicare Medicaid Services this year has made a recommendation to move away from the electronic health record. Medicare Medicaid Services wanted a reviewer to be able to read one progress note, to know the background, the history, the presenting complaints, the findings, and the medical thought process in reaching a diagnosis. They realized that that was a license for cut and paste with no data, with no information. The data rich, but information poor. And we're looking for information. So if you want to see that there are similar things, please look by vendor, and you're going to see identical statements submitted across offices throughout Brooklyn, Staten Island, and Manhattan. And it's a problem. So if we were to take a look at the thousands, as Dr. Weinberg says, and let's put them all, have a computer generate them and cross-reference, I would not be surprised to see so much of a similarity in much of it, but I would hope that the impression and recommendations would be different. And perhaps we can make a recommendation that for somebody who does more than 10,000 IMEs, and we know there are 8 of them, let's do a sample of 100 of those and let's compare them. That would be my recommendation if we want to dispense with this idea instead of kicking it around the table 10 more times.
I just want to say one thing on that, though. If there's an assertion that somebody is not, in effect, actually recording findings from an actual examination and merely they're copying and pasting and not really tying what this is about to particular injured workers, that is something that can be evaluated, and we have done that. We don't have, the ability to scan every single document and do the kind of computer comparison you're talking about, but we can look at the substance of those reports and see if an actual exam was conducted on this actual person and the findings were actually recorded, or if it was copied from something else.
Do you have the ability to pull the last 100 reports of a specific provider?
Yes.
Yeah, we do. I mean,
I
it's
think
a scanned image, so it's not like we can, do a lot of data analytics on it. We have to go in manually and look at each one of those pictures, so to speak.
I think if we look at these very high volume providers and look at their impression and recommendations, and look at 100 in a row or even 30 in a row, and it's all saying no treatment needed, then I think that merits further investigation.
Mindy's.
Yes, Mindy.
So I have a thought that we're sort of discussing this in a vacuum, and I'm not in any way condoning this kind of behavior if indeed it exists, but these reports are used for trials and in front of law judges, so that these people are cross-examined ultimately, and if it's a bad report and it's not substantiated, it's the employer that loses. So I just want to put it in a context here. I think it's important to realize these are not just reports that are used and then everybody says, oh, okay, no disability, or whatever the case may be. These are subject to cross-examination, and, you know, and so if there's not legitimacy to them, I would think at the end of the day, or as an attorney, I like to believe that, you know, they're not going to stand up, or to a large extent, they're not going to stand up in court. So I just want to put that, again, I'm not defending it, I'm just giving a little context. And I would say, if we're going to go doing this with IMEs, and frankly, I see IMEs all day, and there are a wide variety of responses and degrees of disability, and it's not uncommon for us to have a greater degree of disability than the claimant's doctor. So I don't see this. But even assuming arguendo that it does exist, and I'll take your word for it, I would like to state that it absolutely unequivocally exists for treating providers as well. And I know, and so I think if you're going to take, you know, examine 100 reports of somebody, take 100 reports of one of the other, a treating physician, because I don't think you're going to see very much difference. That doesn't make it good, that doesn't make it right, it just makes it a fact.
I would add only that in terms of the prefatory statement you made, and speaking in more general terms as the doctors are, if we know that one IME, generally speaking, is giving opinions that are really not valid, and I'm a lawyer, I'm not a doctor, but if a doctor looks at them generally and says, this are not valid opinions, I mean, not matters of professional judgment, but nonsense, for lack of a better way to put it. If we then have to go through the entire litigation process while the claimant waits for benefits or treatment, and you pay more and lose, then we've all lost.
I just want to say, one thing that has happened in this group pretty much since its inception is the merging of the concept of treatment with the concept of benefits. So I just think that when we're talking about treatment, there's a tremendous, I'm not saying benefits are not important, but, you know, if we're saying that if you've delayed treatment because of a trial, that's very different than, you know.
Well, and I don't know about that only because I've been watching news stories about an entity locally that was a payroll service that decided that in one day it was going to shut its doors, not pay anyone, withdraw all of the money it had deposited from the various accounts into which it did deposit it, which has not only caused horrible things for the employees that now have no food, but have caused businesses to fold because the businesses can't account for the evil that was done by this company. So I think I would disagree that anyone going into work and saying, you're not going to get a paycheck this week, and in fact, we're taking back last week's, that is as important or more important than, do I get the Band-Aid for my finger?
I'm not talking about importance, and I agree with you. I'm just talking in terms of relative urgency. I don't want to delay treatment to a claimant.
Okay, and I like them to eat, so I think urgency and importance can be somewhat said analogously in this case. But off the topic, I think as Joe would rightfully say, attending doctors are not our focus. IMEs are, for better or worse, and happy to come back to the panel that deals with attending physicians and their foibles. But you know, we're here to deal with whether IMEs are across the board not utilizing reasonable experiential bias, but less professional bias, and that's all the doctor's talking about, I believe.
Can we make a consensus that any doctor who does over 1,000 IMEs a year has 100 IMEs random selection during that year, 100 simultaneous IMEs reviewed?
Against what and for what outcome?
To see
Against each other.
Against each other.
Yeah, to see if there is just a
Cut and paste.
well, more than cut and paste, they could all be different reports, but they all find that there's nothing wrong and the person is fine and can go back to work 100%.
Well,
Yeah, so I support that, but I wouldn't say random. I would say we pick a point in time. So the 100 starting September 1st, or the last 100, I want to see a block of them together.
No, 100 simultaneous ones, but anytime during the year.
I think the only way that that would be fair would be.
Random during the day.
The only way that that would be fair, a fair analysis would be if you then called in the 100 injured workers, re-examined them, and all of the data around it. I mean, you really don't, I understand what you're saying. I understand the idea that, you know, you're pushing that there's this inherent bias, but there also may be the possibility that many of the people going to these IMEs have very limited injuries, and perhaps they're
So
treating
let's pick
doctors.
1,000.
So let's pick 1,000 what?
Well, instead of 100, if 100
But
you
we're
don't think will
comparing it
bring
against-
back, you know, you're the statistician from earlier, right? You said
Right.
34 arrests, right, equals 34 cases of fraud in 200,000 cases.
That's not what I said,
So
Joe.
if there's a
It's not what I said, Joe.
If there's a number here that we can agree on, we'll make it 1,000, we'll make it 1,500,
I'll agree on all of them if we can re-examine all of the injured workers
No,
that
that's
are attached to those
ridiculous. Let's
IMEs.
be
And
realistic.
compared to
This
their
is
own
being
doctors.
ridiculous.
That's right.
Let's look realistically at what we're talking about. Why don't we look at the scientific?
You're talking about a
Look for
singular
a
report.
significant number, like a p less than 0.05. We can look at statistics and find out how many do we have to look at in a row where it's no longer random chance that would cause this. You know, you flip a coin 100 times, it comes up heads every time.
Sometimes it does. Sometimes it
How many
does.
times?
Sometimes it does.
That'd be 2 to the 100th power.
That's right.
If we were to look at 300 consecutive reports on patients that had sustained fractures, because there'd be very little dispute as to whether or not there was an injury, and perhaps a serious injury, that could solve the problem. If we pick 300 objectively proven fractures on plain films, not an MRI, and see what those reports say, I think we'd have some data to review, to comment on.
Yeah, but if the
Mindy would
person
like-
Totally impractical.
the exam has anything going on between their ears, they're not gonna do it on a fracture, right?
We don't know.
Well, then.
I would say 100, pick out 100,
Wrong.
pick a date and pick 100 from that date or from that
Pick
week.
100 de minimis injuries and see what happens?
No,
Pick 100 from the date, you'll get some fractures in there.
100
You'll get
sequential
some de
reports.
minimis injuries in there.
Let's stop beating around the
Can
bush.
Mindy make a
Let's do
point?
something as a project and see if we do 100 sequential exams from one of these high-volume doctors and see what the results are. We don't have to do anything punitive from it initially, but there's how many doctors we talking about? 8 doctors? Why don't we do this as a test to see?
Better yet, doctor, why don't we do 4 of the top 10 and then 4 folks from the middle to see if there's a difference, and that'll alleviate Lev's concern about,
Cherry picking.
cherry picking.
I didn't have that concern about cherry picking. My concern was simply that this proves nothing. It proves nothing against the fact that you've got an injured worker that may or may not have a severe or not severe injury. And I can't see that person. Listen, I'm not here to defend the IME doctor. But I just don't think that the witch hunt that you're putting, that you want to put us
Come on, be
into on
realistic.
this.
We know there's fraud out there. You can't say there's not hired guns out there. You know it, I know it, everyone in this room,
What about
these
treat-
rooms know
oh,
it.
forget it.
Let's not
I'm
pretend it doesn't exist. You know,
Can I
what's the
just-
reason for us discussing this if we're not gonna deal with the real issues?
Can we let
Can I
Mindy
just-
speak, please?
I'm sorry, did you want to say something, Mary
I
Beth?
was gonna make a recommendation, I know there's some concern about particular doctors, but, this kind of sounds like, I'm gonna use the term market conduct study, but does it make sense to just look at all IME entities on whether it's every other year or some basis, and do a sampling and look at the range of things that they're doing in the course of providing IMEs as an audit process, as opposed to picking and choosing certain ones? I mean, I think, is that an option for people as opposed to targeting just the top 1,000 or 10,000 or whatever?
Mary Beth, I hear what you're saying, but I think it's important that we look at an individual physician or an individual person who's doing the exams rather than a vendor, because the vendor will have contribution from a number, and any 2 people are going to have a difference. I like the recommendation that we take a look at certain, so we can do random selection across the board, but I think the reports could be looked at and see if we learn something from them. Now, to go back to Mindy's, I made my comment at the beginning from the treating docs, and how the treating docs have cut and paste electronic medical records. And so I think our conversation should be limited to IMEs right now, but Mindy, yes, I completely agree with you.
Mindy?
I just want to say something. I feel like this conversation is not moving us forward at all. And I just want to say, I think that we should maybe consider what we should be looking at in terms of our recommendations, in terms of the things we talk about, because, and what are our goals? And maybe this is something I'm working backwards, or maybe we started with this. But I think the first thing that we have to agree upon, or should be thinking about, the yardstick against which we measure everything, is whether this is providing better health care for an injured worker. And then we want to encourage return to work wherever possible. I don't think this conversation touches these things. I think we want to come up with an efficient process. And to your point, Mary Beth, I don't think audits like that aid in efficiency. I think a transparent process where there's greater levels of trust would really go far towards aiding efficiency. I think we want to have less litigation. I think to the extent that IMEs are, that treating doctors and IMEs give good exams and based on those they come to reasonable opinions that are closer to one another. And I've said this before, I don't think I've almost never, maybe a couple of times a year, do I see a treating physician's report that says the claimant has a 50% disability or a 75% disability. Invariably, if they're not working, it's total disability. And that creates a huge roadblock to moving a case forward.
I take great issue with that last statement.
Let me just finish. That may be different upstate, it may be otherwise, but I'm telling you from my experience, and I'm sorry to actually have to admit that I've been doing this for almost 25 years, that's basically what I've seen for the entirety of that time. And then I think we have to reduce the friction and the frictional costs between, in the system. So I think that to say there are bad IMEs, maybe there are. I certainly know that there are treating physicians who, just like the IMEs, we've talked about bias, we've talked about people having to, they get paid by the employer. Treating physicians get paid by the employer as well. The more they treat, the more they get paid. There's a lot of incentive here for secondary gain. I think we should be looking at the greater good of what's going to get people back to work, what's going to get them healthy, and how can we do it with the least amount of effort within the system. And I think right now part of the problem with the IME issue is it creates lots and lots of litigation, and I think it's the litigation that really prevents your claimant from getting the treatment or the benefits that they're entitled to. So I just want to say that I think maybe if we use those as the yardsticks by which we measure it, we'll get further. I don't think this conversation is really moving us forward in that direction. That's my opinion.
Anyone else?
Can I just ask Justin a quick follow-up to our conversation before we were talking about the anecdotal?
Yes.
And once again, this will be anecdotal, but of the cases, and you said, IME comes across your desk, and you sort of know what it's going to say, or if it's a particular doctor. Of those cases that you've dealt with those doctors, anecdotally, how often do their reports stand? Does the judge say, we're going to go with that one versus yours, versus somewhere in the middle, closer to yours? Just a sense of the actual impact on the injured worker here.
I'd say that probably less often is there the negative impact after litigation, except for having to live through the litigation. So I definitely won't discount that the delay is part of any thing that could be counted as a detriment to the injured worker. But I would meet you halfway in saying, and this is where I lose how to do this perfectly. I look at some of those names and I know that the doctor is not necessarily terrible, but may just be more conservative. And this is a little bit older, a little bit older, sorry, whatever. But
more seasoned.
Thank you, more experienced. But, and so there's a definite difference between when I see the name and I think, oh goodness, I know my eyes are gonna roll to the back of my head again, or those where I say, I've known the doctor for a while, he's always been pretty tight with his recommendations. He tends not to operate if there's a question of whether there could or could not. And, you know, I know doctors that, hey, let's get you in tomorrow. If the OR is open, let's get you in. Better, worse, I'm not a doctor. And so I don't know that that perfectly answered the question. It's not horrifyingly pervasive. But then I still see the doctor's point that if we know the opinion is kind of a little bit less valid on its face because of an implicit bias, not life bias, but other whatever bias, and it exists across the board, of course. If those can be weeded out, I think you will leave more doctors in the system that are earnest in their desire to just, pardon me, do the IME as well as possible and give their honest opinion, and that's when we don't have a problem. I mean, I'll even go so far as to concede that there have been times after litigation where a very smart WCLJ found, no, your client's not going to have the surgery, and I said, ooh, that's probably a good thing. But that's, you know, I'm just a lawyer, not a doctor. So sorry about the long-winded answer.
No. You know, it just makes me, I mean, listen, the fact that a claimant has to go through litigation, and you know, I understand, and that's difficult. But, you know, my members and all employers across the state also need to have access to due process, right? So that litigation, the fact that there's litigation notwithstanding, I mean, it's part of the system. We get a defense, it's going to happen anyway. And you know, what I'm hearing from you, and granted it's anecdotal, but you know, this is not, regardless of this handful of doctors that are performing an enormous amount of IMEs, this is not really moving the ball very far, one way or the other, for claimants and what they end up getting for awards at the end of the day. It seems much ado about nothing at the end of the day. Yes, there could be an implicit bias, I think, on all sides. I think you just stated it. Mindy certainly stated it and seen it. I think that there's simply no question. And there's also no question to weed out certain biases among all of us. But to go down the road of a process, outside of where the board can look into actual, like, obscene kind of fraud, to try to create a system where we're going to weed out some kind of bias, I mean, you know, this Pandora's box that would be opened by doing this is frightening, because honestly, I won't stop there. I mean, obviously, we will call on, you know, investigation into providers. And the board has been doing a pretty good job of, you know, looking at providers who have been doing bad things, and we've also gotten emails about them removing some of them, or temporarily removing some of them. I just don't think, from sort of what you're telling me, that delta is so great and this problem is so big that we need to spend any more time, or certainly come up with a list of recommendations on how to deal with a fraud that has very little impact at the end of the day on an injured worker. And I'm not saying none, but very little, based on what you just told me.
I guess
When it comes down to it, the legislature has tasked the board and this group with exploring this issue. And I think that to walk away from this aspect of it would be to abandon our legislative directive here. This is relatively simple. The board can do it. I think that taking a look at 100 consecutive reports from some of the Power 10 and 100 consecutive reports from some of the folks who don't do as many would provide some information here. The fact that you know, one person on this committee thinks, or two people think, that the bias isn't worth looking into, I mean, the committee was established by the legislature to look into just this type of thing. So if it's not worth your time, you know, don't come to the meeting where we discuss it. But I don't think that we should be hamstringing the board here.
And I would be less inclined to go down that road if it were my idea versus something that bona fide medical providers in the system are suggesting. So I don't want everyone looking at me thinking that some lawyer came up with the idea that maybe this would be a good idea.
Well, we have.
And also to point out, my memory is that Dr. Weinstein, he treats injured workers, and he also performs these IMEs. Is that correct, doctor?
Yeah, that's exactly right. And as a treating doctor, I want to be able to treat my patients and get them better. And I think, honestly, as in doing IMEs, as a doctor does IMEs as well, it keeps me honest, because I'm thinking this is a real patient for someone. And my concern is the doctors who don't think that way, you know, whether it's on the treating the patient side or the IME side, the ones who just have that bias from, I'm going to give them the report that I want to give them, I don't care what I really see, I'm going to ignore their complaints, ignore the MRI findings, ignore their exam. Those are the doctors that we have to stop on both sides. but it's the IME doctors, and it's, a very small number of doctors who are doing a fair number of IMEs and messing up the treatment of these patients.
My concern there
Have
is,
you referred them to the IG or to the board?
No, I have not.
my only concern, and I don't disagree with what you said, Doctor, I as far as, calling out bad actors. But my problem is taking 100 random or 100 not so random reports and just looking at the paper, I think gives us very, very little. I truthfully don't think that it's a good way to approach it.
I appreciate what you're saying, but I completely disagree.
May I add something?
It would have to be randomized.
Just on the,
David?
Have to be consecutive though. Consecutive.
just on the administrative side, just to note, if the committee is going to recommend that, the board, let's say if somebody's doing over 1,000 or whatever number, that we take a look at 100 and do in effect a quality comparison, I think the committee would also need to recommend that the board's authority to remove these physicians needs to be expanded. Because if you're getting into, arguments or discussions about the quality as opposed to an actual misconduct finding, if the law just remained as it is right now, that removal would be undone in an Article 78. I have no doubt about it. So, if that's the direction the committee wants to go down, I think the board's authority would have to be boosted to include removal for quality review issues upon audit.
I was just gonna finish what I was saying before, really quickly. I just think that reviewing paper is a mistake. I think that if you videotaped every one of these IMEs, every single one, we would get to the bottom of it really quickly. We would know whether it was a valid IME, if they were told the patient was completely checked out, and if it was done properly, and then the rest of it becomes opinion, professional opinion. And listen, I've been wrong 1,000 times, but it doesn't mean that I was acting fraudulently. I'm just stupid.
I just want to make sure that I understand. You're suggesting that taking a look at paperwork is not probative? I mean, the entire system is built on reports, is built on paper. So, the other thing is, Mindy, you asked Dr. Weinstein about his referrals to the IG. All of these providers that you suggest are behaving fraudulently, do you report them to the IG?
Actually, yes. Occasionally.
How many?
I don't know off the top of my head, but if we have a problem, we do we make the board aware of it, yes.
So not the IG? How do you make the board aware of it? Is it a formal complaint that there's some type of fraud going on?
I don't think that this is an appropriate, you're not cross-examining me today.
I'm not, but you asked the question earlier so as to discount what Dr. Weinstein was saying, so I just wanted to figure out what you think would be the appropriate thing.
Right, so
what
I'm saying is appropriate is you can contact the board. David said you can contact the board, you can contact the IG's office. If there's a problem that you see, you can. If you don't, then maybe you don't think it's such a big problem. I don't know.
Is this something where, for purposes of the continued meetings, because this is not the last one, we might be permitted, the committee members, to provide some additional thoughts on this topic, given
I think so.
what's been said today? I mean, I'm not trying to short circuit the discussion. If we could,
And we're gonna be talking about your recommendations, so this could be part of the other. We're
Right.
gonna jump into that
Okay.
shortly, so this could be something that you recommend.
But I
as a
would like to
committee.
give it some thought, because this may be something I'd like to place on record as
Right.
part of the
Okay.
proceeding.
So before we move on, can the board logistically perform this review by the next meeting?
I don't know that we can. We can look, it's in our parking lot. I think we'll discuss it and we'll see if there's a way of doing something like this. But I think it looks like it would be more a recommendation from the committee, along with the rest of your recommendations. Is that correct? And then that's something that the legislature could look at.
I just want to clarify, so I think
Yeah.
Joe's ask is that he wants us to take 100 exams from one of our top providers as a sample, and 100 exams from somebody who's in like the mid-level, and review it for, potential misconduct, fraud, whatever the case may
Quality.
be.
Biased
Saying
results.
the same thing
Well, yeah,
every
for,
time.
right, yeah, exactly, just say it's duplication, just different name, whatever the case may be. So that's a now ask, so that information we provide to this committee to make recommendations or not on fraud going forward. I think that certainly.
So that's one recommendation, but when it comes to doing a review like that, you have to be careful of what's called sampling bias. And so when you think about this type of work, you have to be very, very certain that when you're sampling, you're not biasing your sampling, because you don't want to draw erroneous conclusions because of the sample and the sample size and what's in the sample.
So what's your suggestion to alleviate sampling bias?
I'm not going to opine on that. If you were going to alleviate sample bias, it has to be a randomized sampling.
So how do you ensure a truly randomized sampling?
That's through like statistical methods, right? I mean, you kind of goes a little bit above my where I am, but certainly when we think about these types of things, polling samples and whatever, there's margins of error, and you have to ensure that you're not going to have any bias in your sample.
So I didn't realize that there was a terminology for what I was thinking about, but I was thinking about sampling bias earlier, right? If the person who's picking out the sample wants to say, or wants the sample to show that everything is fine, right? They'll skew it and pick out the ones that show that everything is fine. I was thinking of some type of time, consecutive reports during a certain period of time. So the first 100 starting at 9 a.m. on September 10th, the first 100 after that, or some type of block like that, so as to alleviate that type of bias in the selection. I think that you would do it with one or a handful of docs, and I think that to show the difference between the folks, the power folks and the folks who are just doing this as part of an ongoing practice, diversified practice. You pick a couple from the power 10, and then you pick a couple who treat injured workers as well.
Sitting here right now, I don't know what would be the best methodology to ensure that you don't have bias in your sample, but it's something that kind of is recommended to perhaps be tabled for further thought and come back with some recommendations on how to alleviate or minimize sampling bias.
Well,
Can I just follow up?
Your recommendation is that if you table,
yeah.
my request is that the board look into it and try to deliver results by the next meeting.
Right, I
Well,
understand that,
then,
and,
Beth, yeah.
and I guess my point is, I can pull 100 sample items, we can find a statistical way to do it, I'm not concerned about that. What I'm concerned about is what exactly are you asking us to look at?
Right.
Short of finding the same exact report with just different names on it, what is, are you asking our medical director to somehow review these case files and make a determination about whether or not they made a reasonable assumption on what level of disability? I'm very concerned about what the task is you're asking us to do with each of those two sets of case files.
Right. So like what work would be done, what would be the output of the
So
work,
what,
and then what
yeah.
would you do with the results? That would all have to be defined before you endeavor upon doing the work.
I'm not sure how the medical director would be able to review those files without the patient there.
Well, I
To say
guess
whether it's valid or not.
those are logistical concerns that I would like to clarify. If there's an ask, and we're here to serve the committee, but I need to make sure that there is a general agreement about exactly what's being asked and that it's a viable task for us to complete.
We'd also have to take into account the litigation context of the case. Is it pending? Is it done? Is it developed? Is there a decision?
Right.
So
So I just think
There's
it's
a
a
lot of
very dicey situation it sounds, fine as far as like a procedure to do, but the implications of it, I think, are much broader.
I think that a good place to start would be deviation on degree of disability between them and the treating physician.
That presumes that the treating physician
It's
is
telling the
giving
truth.
a reliable degree of disability.
But then you're not random anymore. Now you're zeroing in on specific factors. And, I think there are a lot of variables in those
So-
samples.
It's still random.
I feel like
It's
this
still
is.
It's
I
still
feel
random
like-
numbers. It's not anything that's not random. You're doing simultaneous. When I do scientific studies, doing 100 in a row is random sampling. You don't pick and choose. It's 100 systematic pulling 100 in a row is random. So it's not a sampling bias. My recommendation, what to look for, is to look at the impression and treatment recommendations and see if they are pretty much consistent for that 100 in a row.
What delta becomes problematic?
if they're pretty much all exactly the same, saying that the claimant does not require any treatment.
Well, but if we're comparing them to the impairment evaluation from the treating physician, you're implying that, the big problem is the delta between the two, right?
Well, I think that
No.
you'll be able to tell what delta presents a problem if you see a big difference between the folks in the middle and the folks who do this solely to sustain themselves.
But we may also be seeing all kinds of other things, right? Some might be upstate, some might be downstate, some might be dealing specifically with construction injuries.
Four at the middle, and the four at the top are totally different from each other, and the four at the middle are totally different from each other, then you know that there's a reason to question the statistic validity. But if you have the four in the middle are pretty consistent amongst each other, and the four at the top are pretty consistent amongst each other, and then there's a big deviation between those two groups, I mean, then the probative value is pretty clear.
I disagree. There's simply no constant, and I don't think that there's anything to come out of this except a fishing expedition.
Part of the problem with this system is people's refusal to consider doing it a way different from how we've done it in the past. And I think that this conversation really highlights that for me and anybody else who's of that persuasion. I had a conversation recently with someone about the quality of medical care in the workers' comp system. And I know this is a little bit off topic, but
It's not on the table. We're only talking about IMEs here, Joe.
So absolutely, it's anathema to me to think that why should we consider that someone who got hurt in service to their employer should have better quality care than folks who are out there in the healthcare system in general. And it's the type of thing that nobody would even consider because, well, it's never been done that way. So this is another example of that, how it's never been done that way, so we shouldn't do it that way, or we shouldn't even consider it.
I think at this point, we will take a break, because I'd like the workers' comp team to potentially think about this and what the ask is. We'll come back at 1:30, and see what it is they can do in the short and long term, and that's it. All right, let's get started. We've had the team at workers' comp has had the opportunity to talk a little bit about our previous discussion, and we think the best approach to ensure that everyone's opinions.
Are we muted? Joe and Bob seem to be
Okay.
involved.
Gentlemen, can you hear us? We're going to resume.
Are we muted?
We must
I don't know.
be.
I don't know.
It's green now.
Don't
Looks
ask
like,
me.
Present.
Okay, thank you.
looks like they heard us. All right.
We think
They
the
just
best
did.
way to continue this discussion is to ask that all of the members of this group submit recommendations to the team here for us to review, and we will kick off the October meeting and try to resolve this. Is everyone okay with that? Because we are
Do you mean recommendations?
on fraud and abuse,
On this topic.
on this topic.
Would the board be willing to circulate an additional page of our questionnaire here, or something that we could fill out same way and just append to whatever documents we've done thus
Very well.
far? Or would you
Well,
rather?
there is a section in the back on fraud, so we'll get
Okay.
to that at some point today. So I think we wanted to circle back on the ask for the sample. And so the question of the sample, I think from our perspective is, if people want to give us very specific things in a sample to look at, where we would be able to check the box and give you back data, potentially to the extent we can crystallize those questions, we could technically do that. I think the bigger question though is, let's just assume it does come back and confirm one or the other, either that, at one of the two groups, there's a definitive pattern, or there's not. But I think what we heard today was that there's basically, most people in this room probably can say that they've seen that particular provider that gives you a report that's maybe not accurate. And we're not saying it's across, a widespread issue, but there are definitely providers who do it. So just, aside from the polling of the 100 cases, what would we do with it, even if we confirmed it through the sample? What is the outcome of the data? Because I don't think anybody disagrees that there are those providers in the system that ultimately are not doing what is expected of them as an IME. Whether it's a bias, whether they're just using cookie cutter reports and changing the names, whatever the case may be, let's just say there are a sprinkling of those. What is going to be the recommendation on how to deal with those people? I think that's the fundamental question that the legislature is asking us to look at. What are the recommendations to correct that type of behavior?
We talked about education in the past, Mary Beth, to respond to your question. Perhaps we should think of a recommendation of an educational program that would be made available and perhaps requires certain individuals that if they're found to be behaving in that fashion, attend them or perhaps teach them.
Or you can just stop people from doing thousands of IMEs, which was also
So that's
discussed.
the daily cap. So maybe, and again, I think the last piece of this in our detailed question that went out is, I think there was a question on fraud at the very back. So maybe what we could do is, so some of these themes, I think, keep circling back to this overall questionnaire, where do we need daily caps, do we need annual caps? So let's start to talk through the specifics in this. We'll kind of get a sense of where we're headed, if there's any consensus. And then by the time we get back to this fraud piece in this questionnaire, maybe we'll have, kind of given us a little bit more sense of where we want to go with it. And it's still an open topic for the next meeting. If people want to think it through for the next meeting, we can certainly continue to talk about it. But I think our only concern was in pulling that sample, it's not that we can't do it. I mean, we do have a lot of system limitations, a lot of manual work, and I do think we have concerns about, like our system doesn't allow us to say what's the range between the treating provider and IME to determine like how far apart. We just don't capture that kind of information. So it'd be a very manual effort. And like I said, if people feel strongly we should do it and they want to give us very specific tight questions that are not judgmental, because I don't think that we're in a position to judge some of those reports, then we can talk about doing that survey. But otherwise, I think, if we take it up to the next level, what is the ask? The ask is to correct behavior that's inappropriate, and then the question is, how do we do it? So if everyone's okay to kind of move into the survey, we'll continue to talk about fraud at the next meeting. But I think some of the themes will come back to us through these questions as well. So the first thing, and I think this is kind of coming back to the whole fraud issue, is should there be a day cap on the number of IMEs any one provider can do in a single day? So you have a document in front of you that was part of the materials that kind of summarizes where the responses came in. So for this particular question, 7 committee members disagreed with the daily cap and 4 agreed. And it looks like some are suggesting maybe a weekly cap, others disagree and feel that if we have concerns, put some type of caps in place that'll exacerbate the number of people available, and potentially, questions about how would you actually enforce a daily cap. So it looks to us that we don't really have a consensus that there should be daily caps put in place. Any of those who feel strongly, certainly feel free to weigh in. I don't want to speak for the group, but I'm just trying to give you the kind of the feedback that came back from that question.
I feel strongly that we should recommend caps, but I would ask the folks who disagreed, are you movable on this, or is this something that you don't see? We're talking about value of our time here. Is it something that we should spend some time on or not?
Sounds like a no to me, Joe. But I mean, and the next part of this is the annual maximums or minimums or maximums. So I guess the question is, if daily caps isn't the right categorization, are there things like an annual maximum or an annual minimum that people want to consider in lieu of a daily cap?
Well, the problem is, it seems that got even less votes, and
Yeah,
frankly,
no,
the only
exactly.
2 there are me and Joe.
Right.
So I'm certainly not movable vis-à-vis your position, but I'm not the one.
I think I voted against the annual minimums.
Yeah.
Oh,
That's why I printed mine.
oh, sorry, okay. Oh,
It was human just.
I'm sorry.
You guys, there's this other, I don't know if you have the matrix document, it kind of tells you who
I'm getting
voted
confused.
how.
Oh,
Yeah,
It might be
okay.
helpful.
Oh, got it.
Yeah,
Sorry.
and this document has the actual comments. So the first page will
Oh,
also
so we
give you a
have the data.
synopsis of the answers, but the second, subsequently, the actual comments.
Now I know how to read this, thank you.
Yeah, I apologize.
No, no
We gave you a lot of
worries.
materials.
Okay.
I probably should give you the walkthrough.
I know, it was a lot of paper this time.
Thank you.
So I didn't see any strong willingness to come to consensus on a daily cap. And then it looks like we're potentially, even further apart on some type of annual minimum. I think the concern is it will drive providers out of the system, because as you recall in those statistics, we had a large number of providers who do, less than 5 a year. So if we set some kind of annual minimum at like 20 or something, they would probably just drop out. And so we'd have even exacerbated the problem we have with the shortage of providers.
And I guess, as you said, a lot of these things are going to intersect, but if the ultimate conclusion of the committee is no caps, then I think the argument for doing some form of a qualitative review is that much stronger, but just a comment.
Right. And that's where I think we can talk about, how would we get at those high volume providers? Is there another path besides just a flat out cap? So I don't know that we have any consensus on the volume on caps for providers. Do we agree?
Yes.
Okay. So then the next section under B is the availability of the provider specialties. So one of the questions was, should we allow telemedicine to be used for IMEs? Oh, I apologize, maybe I jumped. Are there other recommendations in that first category that people wanted to discuss that we didn't discuss? I don't want to, pass over people's comments if they want to raise any of them.
You don't have an annual cap. If you don't want a daily cap, what about an annual cap? To have thousands being done by very few physicians seems curious.
I think that's what number 2 is. It's just erroneously
Yeah, we
No,
asked
I-
about
labeled here,
minimums.
isn't it?
That, no, because
caps.
2 was minimums, and that I did disagree with, because there are some upstate smaller providers who are wonderful doctors that do a few each year, and I don't mind seeing them, so I don't like the idea of an annual minimum, but I did write that maybe an annual maximum wouldn't be a bad other recommendation.
Yeah, I'd be open to an annual maximum as well.
So would I.
Yeah, we feel the same way too, the doctors all agree.
So is there someone that disagrees, I guess?
I do.
There you go.
I don't think we've established that necessarily there's a correlation between the number of IMEs you do and the quality of the IME, and what the result of that IME, and whether it's favorable or unfavorable to the claimant.
So is that,
Yeah, I would tend to agree. I mean, you don't want to take a doctor out of service just because in October he's reached a certain number. And with the small number of IMEs that we have in a lot of rural communities, it's going to exacerbate that problem.
but what if that number is 5,000 by October? That's more of what, I mean, I don't want the smaller providers to do that either, but, we're talking about doing this kind of qualitative review of the people that are doing thousands of these things each year. And so either we dig into the guts of it, or we just say, listen, you can't do thousands each year, you can do 3,000, or whatever the appropriate number is, but you are, and I don't know how the board would monitor it, but that would be the thought there.
When we first saw the numbers, in the beginning of this venture, that handful, they stuck out like a sore thumb, obviously. There was 1,000 or whatever it was. But then as we broke it down, and we understood that it was for, whatever the period was, and we broke it down to the daily, the numbers were digestible on a daily. Granted, some of them were a little far-fetched. I'll grant you have to do X amount a day. But, I spoke to a number of IME doctors in the last, month and a half, actually, 2 months or whatever it was, and asking them what is your output on a busy day? So you've got doctors who, are practicing whatever specialty it is 4 days a week, and the 5th day they do IMEs. And the answer that I got from every single one is, as many as I can get in on a given day. And I said, well, can you validly do 5? Absolutely. I could do 10. I could do 15 even if I can get people in, as long as I'm reviewing documents, on a different time. So it's not, in my mind, completely obscene or, out of the realm of possibility that the numbers that we saw are doable. I mean, granted, they're high, and granted, all of the things that everybody has said around the table, but I don't think that any of the numbers that we saw, and I don't have them in front of me, I don't think any of them were impossible. Like if it was 5,000, I think, now we're talking. But if it was 1,000 in a year, I think it's doable. And so where do you cap it? 1,200? 1,800? 800? And you don't want to part of the problem in the state, or the one that was truly identified, was that there aren't enough doctors doing IMEs. So shrinking the pool even further of those that are available at any given time is not going to be advantageous to injured workers, and it's not going to be advantageous to employers who are going to pay another week of temporary benefits also as we wait, right?
I think we would perhaps want to give some deference to the physicians on the panel as to what they feel is doable, what's reasonable, a year, day. Again, I'm not wedded to any one particular thing, but you can ask me how many clients I can meet within a day, and granted, it's different than those Ralph can meet within a day. I like hour meetings, he likes half an hour. But I don't know that I can speak for the for the physicians as to what's really doable and what's not. I think any IME doctor is going to say, yeah, I do as many as I possibly can, but I think that's what we're looking to kind of avoid.
One of the things that I heard Lev say, which was important, goes, provided they read the records at another time. I believe the reading of the records and the digestion of those and finding out the meaning on those papers, we talked about workers' comp being very paper-oriented, takes a considerable length of time. So if we're talking about one day, and I'd be curious to know how the breakdown is, how many devote one day to it, because it came out that they would have to be doing 7 or 10 a day, 7 days a week. That's a very high number when we did the math for those few that are there. So rather than to be punitive, wouldn't it be wonderful if we could get the IME vendors to look to that next group of people that do somewhere between 25 and 100 a year and refer individuals to those offices to increase their volume, improve their ability to handle them, their interest in them, and I believe we'd be able to address some of the problems that the board is facing in getting enough high-quality IMEs available. If you're only sending them to 7 people, you're only going to send them to 7 people. If you send it to 70 instead, you're going to get a whole lot more. So I make a recommendation that we look to increase the distribution by asking the vendors to broaden their panels.
I don't recall, does the number of IMEs include medical treatment guidelines exams on single issues?
It's all IMEs.
Only if they're IMEs.
Only if they're IMEs, not record reviews.
Right, that's right.
All right.
Do we have any idea, I mean, how do we determine what even if this were something that were wise to do, how would we determine what the actual number would be?
And again, that's where I think I would take the lead of the doctors that do this versus the attorneys that just read the report, but obviously that's just one opinion.
Is it possible to find out how many patients does a treating physician see?
Well, I can tell you, as the only orthopedist who does IMEs on this committee, I do IMEs typically once a month, sometimes twice a month, and I will see approximately 15 people for an IME exam that day. And as Dr. Goldberg was saying, it's not hard to see that many claimants. The hard part is going through the records, and sometimes the records will take me 10 minutes, sometimes it will take me an hour. So it's really, the time invested is not so much seeing the claimants, it's going through the voluminous medical records. But I think 15 to 20 claimants in a day is not anything obscene. But if I had to do that every day, I would kill myself.
That's, you're doing that notwithstanding. That's 3,750 IMEs a year if you did that 5 days a week for 50 weeks a year.
So
So
that's my point. I can't do it every day.
You
I
can.
do it,
You
see them
can.
claim it that day.
I get
and
that.
Over the next 2 to 3 days, I go through the records and generate the report.
So, I mean, but even if we cut that number in half, meaning that a doctor's doing it 2.5 days a week, and that's all he's doing, for instance, or maybe he's seeing patients 1 day a week, we're still at a number near 2,000 IMEs annually to fit the schedule that you just said that you did. So.
Yeah, but I have a very busy practice. I'm seeing 60 patients a day in my private practice.
Understood,
wait.
that's my point.
That's-
If I'm only doing IMEs, or if I'm doing IMEs most of my time, right? If I'm doing 50% of my week, 50 weeks a year is being spent doing IMEs, the rest is doing other things in practice, using the numbers that you just said, the low number, because you said 15 to 20 and I multiplied by 15.
Yeah, but you're saying, I'm not saying that's one day, that's 2 to 3 days of work. That's 15 to 20 people that I see, and it takes me a day or two to go through all the medical records. So it's not one day 15 to 20 done, the next day I can do 15 to 20. With the medical records, it's probably 4 to 5 times as long to, maybe longer, to go through the reports than to just see the claimants.
If I had my office open 2.5 days a week seeing IMEs at the rate that you did, is it conceivable that I could go through all of their records in the other time I had?
The other 2.5 days?
The other 2.5 days, plus there's a weekend. I work on weekends.
But then that would be 30 per week as a cap, right?
Pardon?
That would be 30 per week as a cap?
No, it wouldn't be. It would be 37 and a half, but I'm not talking about doing, I'm just saying that at the end of the day, you know, we're still talking about enormous numbers, bigger than those that we saw on you know, at the first day. So my point is, you start to talk about annual caps, we're gonna get into where there are going to be legitimate providers who are gonna be limited for no good reason, other than we want to set some arbitrary cap.
But we should also use the term providers appropriately. A lot of these IME high-volume people are no longer practicing, so they're not providers anymore. They're not providing medical services. They're IME employees, I don't know what you want to call them, but
Do
they're
we
not
call them
providers.
doctors?
But I would
Are they
also-
doctors still, or they lose that?
They're not acting as doctors by generating this report, they're not treating. One of the definitions of IMEs is you're not a treating physician.
Can I ask a question? I just want to be clear that what I heard, doctor. You said in your regular treating practice, you see 60 patients in a day, is that right?
Correct.
That's completely irrelevant to the time that it takes to do an IME, reviewing a case from the very beginning. If you've never seen something before, that's apples and oranges, and those two things
Exactly, because
should
when I'm
not
seeing
be
the patients,
compared.
exactly right. When I'm in the office seeing a patient, I get the history right there, I examine them, and I do the note, and it's done. The IME, I have to go through 100 pages, 400 pages of records, and that takes so much time. So it's not just the examination. I think it's really important for everyone who's on this committee who doesn't do the IME exams to realize the exam's the easy part, getting the history is the easy part. It's reviewing the records that makes it difficult for us, and that's why so many doctors don't want to do these exams.
Well, can I just
And
ask?
it's not just reviewing the records. The case I'm looking at right now has 6,000 pages. Then I do an exam, and then I have to take the information from some of those 6,000 pages and use them to support my diagnosis and my impression, perhaps to reinforce treating doctors, or perhaps challenge treating doctors. And it's not just reading them.
Is that-
It's reading them,
I'm just
understanding
curious.
them, and using them.
Doctor,
That's right.
is that a workers' comp case you're working on there? Or a liability case?
No fault.
Okay. So I just want to say, is it often, doctor, that you get voluminous medical records? Because in my experience, you get the diagnostic tests, maybe the first treatment.
Depends on the length of the case.
So the point being, you can do an exam pretty quickly, is that right?
The exams may be 15 minutes to an hour and a half, but it can take up to 20 hours or longer to review the records, and yes, for individuals injured at work.
Okay.
There's tremendous variability in what we're talking about. An exam, for me, it could take 5 minutes, it could take 15 minutes. But it's, the records could-
I'm agreeing with Dr. Weinstein. If you're talking about a sprained wrist or
Yeah.
finger compared to a spinal cord injury with multiple fractures, they're very
Correct.
different, but they're both an IME.
But
That's
isn't that
exactly
the
right.
very reason why these caps would be not helpful? Because the variety and the possibilities are so great that really how does it inform the result?
Tremendous variability is what you just said.
Yeah, there's tremendous variability. But that also goes back to what we talked about many weeks ago, is if these doctors are treating physicians, not just IME employees or whatever you want to call them, they will not be able to do 1 million IMEs a year.
So just for some perspective, I pulled up the chart we had looked at with our top doctors before. And it looks like the average of the top is in the neighborhood of between 1,000 and 2,000 per year, if I have this list right. So even if we talk about the 5,000,
That's seven a day, full-time.
right, so I feel like just to get to sheer numbers is not driving the correction you're looking for. Because you could have somebody who does it one day a week and jams through a whole bunch versus somebody who might, do their 1,000 over the course of, every day in the week and over 12 months. So I'm not sure a pure number is fixing the problem you're still looking to address.
I agree.
Then we're back to the pure qualitative review, though, unfortunately.
Right, but again, I'm just trying to close out
No,
question one.
understood.
But moving forward.
I know.
It
So
is
I'm
2
not
o'clock.
sure that we have a full consensus on any type of cap, maximum or minimum. I think the concern is still with those high volume, and again, I don't want to say that all the high volume are necessarily bad, just there's a concern about, the thoroughness or the consistency in those, the sheer numbers. But putting a cap in doesn't seem to be, there doesn't seem to be consensus and doesn't seem to necessarily get at the concern that's being raised for those particular providers. Is that a fair summary?
I think it's fair.
Yes.
Okay. So should we move on to the next topic is the allowing of telemedicine to be used for IME, possibly for some types and not others. It looks like we were very split on this. Any feelings that we might be able to move towards telemed for even certain types? Like, there's been some suggestions in there for maybe just like, for social workers or for psychiatric assistants. So do people have just a flat out no telemedicine at all? Or are people willing to look at certain types of telemedicine?
Well, when it first came up, somebody, I think maybe Dr. Goldberg mentioned that a scheduled loss of use examination might be amenable to doing by telemedicine if there was a physical therapist present to perform range of motion measurements and such.
Do something.
No, and I have to speak for myself. If you look at my response, it's no, because of the importance of the physical examination, which doesn't begin in the examining room, it begins when the patient enters the office. And feel very strongly that it can't. But Mary Beth spoke about social workers. I'm not a social worker. Have social workers been asked about that question? Might it be relevant for a psychosocial background as opposed to a physical schedule loss of use or other determination?
And that's a point that I had not thought of, but I'm willing to agree that if the purpose of the exam is psychological only, that's an interview. It's an interview done in a room, and psychologists treat telephonically, but anything orthopedic, anything that requires a physical examination, be it because the doctor feels that observation of the claimant is as important as the exam, or because I feel that I don't want a surgery being denied by an orthopedic surgeon that has not even done, anything, that's that. And so I have a tiny bit of wiggle room there, but nothing for physical injuries.
So potentially just the psychological services.
Well, I read a neuropsychologist's report this morning that included a lot of commentary about observations made by the doctor during the course of the interview. And, I'm going to Rochester tomorrow for a hearing that I was given the option to do by telephone. And I've decided to go because over the telephone, I can't read facial expressions, I can't read body language. Those things are important in a psychological exam. So if I said that I like telemedicine on my response, I've changed my mind.
Okay.
I don't like it.
I want to support what you said, that's psychological. I asked if a social worker was asked for a social profile or background, perhaps support, if we need to provide assistance for food, dwelling, household, shelter, that I think I would be in favor of, to get it in line fast and not delay it. But to make a determination of PTSD, coping mechanism, obsessive compulsive behavior, I absolutely want that psychiatrist or psychologist with the patient.
Okay, so sounds like we're going to not reach consensus on telemedicine. Does that sound like a fair
Well, actually, the consensus thus far seems to be that it should not be done. At least that's what I heard.
Right, so there's no recommendations to allow it.
Oh, exactly. The recommendation
Right.
is to stay status quo, not to allow it, but
Correct.
not to not make a recommendation.
The recommendation is to not allow telemedicine.
Okay.
Got
Well,
it.
to not change the law with respect to telemedicine, right?
Correct.
Sure, it remains status quo.
Right, because
Okay.
it is something that
Right.
could be considered in the future with more further study, and not just in IMEs, but in the larger context of
Okay.
treatment.
So no legislative change recommended, remain status quo in telemedicine. Okay. So the next topic is the method of selection and assignment. So there was a question about rotating panels. For the board to establish rotating panels of 3 IME providers, and both parties would be entitled to deselect one name from the panel. So on that, we had 8 members that disagreed, 2 agreed with the concept of rotating panels, and 1 had no response. So it seems like there doesn't seem to be consensus to make a recommendation about having rotating panels. Is that, anybody think that we can reach consensus to change and accept rotating panels? It sounds like it's pretty remote. Okay. So there was also a similar recommendation on rotating providers, where the board has board will be a network responsible for assigning authorized IMEs to perform an exam or records review. Board administered, network administered program. Same thing, roughly 7 have disagreed, 3 think it might work, and 1 had no response. So I don't know that we can reach consensus on a rotating provider recommendation. Does anybody disagree with that? Okay.
While I don't think we can reach consensus, I do want to say I think that this would be one of the best ways that the board could eliminate bias, or at least limit bias in this system.
And that's what I submitted in my response. I agree with Joe for both the panel and the providers, and I think would really address the bias as well.
Okay. Next topic is the IME provider types. I'm going to turn that over to David.
Okay. So we just almost touched on this a couple of minutes ago. We were mentioning social workers, but the first question was with respect to partial parity for nurse practitioners and social workers, which are specifically prohibited under the expanded provider law. They can treat, but they cannot perform IMEs. So the suggestion number 1 is the partial parity, which would mean that if the claimant was treated by an NP or an LCSW, that the carrier would have the option of using an NP or LCSW IME. And I know it's an option because one of the disagreements was that it would empower the claimant to interfere with the employer's choice of the IME, and that's not the suggestion, it just would give the option. So anyway, 4 agreed with partial parity and 6 disagreed. It looks like there's no consensus to go forward and recommend any legislative change. So what that would mean, if that is accurate, is that we will go ahead and implement the expanded provider law as of January 1st of next year, but maintain the status quo from the enacted law of not allowing NPs and social workers to do IMEs. Does anybody disagree with that statement? Okay. And slightly more so for the full parity question, which would have allowed, even in the event that the claimant did not treat with an NP or an LCSW, that the carrier could select, or that the claimant could select for a claimant IME. And I'm assuming, just disagree if you want, but I'm assuming it's the same answer, no consensus. So next, with respect to active treatment, potential recommendation was to require all the IME providers to also have an authorization to treat injured workers And that could be coupled with a requirement that they do treat injured workers, perhaps a minimum number in any given year. Excuse me, among other things, it would prevent retirees, sort of in the situation Dr. Weinstein described, folks who are not doing any active treatment and would only be doing IMEs. It would prevent them from doing so by having the active treatment requirement. On this, one of the statements in agreement said, we don't want providers whose sole income comes from doing IMEs, since this may lead to bias. And one of those who disagreed, actually most of those who disagreed did so because of the risk of exacerbating the current shortages that exist in certain areas of the state. Those seem to be the two poles of thought. So 5 of the committee agreed with the active treatment requirement, 6 disagreed. It looks like there's no consensus, but certainly we could throw it open for discussion if anybody wants to try to move that forward.
I recommend that we have an active treatment requirement combined with a requirement that all doctors who participate in the system as providers also perform IMEs. If you do that and the board assigns them on a rotating basis, in my mind, that alleviates the shortage of IMEs and it alleviates much of the bias in the system.
I agree with the middle statement of Joe's 3.
Being.
That
requiring
well,
them
that
to do IMEs?
requiring IMEs, yeah, from active participants in workers' comp physicians, and I think we see where that goes. And if the pool opens up and we have less of a problem across the board, more people available for IMEs and more IME doctors doing fewer IMEs, if you will, we could reassess it some other time. I don't agree with point A and point C, but point B was excellent, Joe.
I aim to please.
I know.
So there seems to be a pretty stark divide here, not to set up sides, between everyone who is either a medical provider or on the claimant's side of the table and everyone on the other side of the table, for lack of a better way to put it. Is that truly the objection, that everyone thinks that we're not going to have enough IME providers? Just most of the other issues were not that starkly divided as between.
Well, that was one of the things I wrote. And I also wrote that I've dealt with providers who are not, IMEs who are not in active practice, who I find very credible and have found very credible, and I've had claimants' lawyers tell me that they were very credible. So I don't want to preclude those doctors from providing services as IMEs.
And for what it's worth, during our March convening, we were presented with some data that actually 86% of the IME providers are also actively treating. So just a reminder that 86.5% do both. So maybe it's a non-issue in that regard.
But wasn't the very high provider numbers that the ones who provide the most IMEs, weren't only about 30% of them treating?
Yeah, let me see, that could be the case. But the
I think
majority
they were
do
higher, they
both.
were authorized to do both. Whether or not they do both is a different question. But a lot of them were already authorized to treat.
Yeah, this
Just
data
maybe
says
just-
that they were actively performing IMEs and actively treating, but
Yeah.
So
just kind of looked at my notes again just to see. Of course, I can't make this bigger.
I'm just waiting to see, are you looking for that
Oh,
answer?
no, I'm
or-
done.
Oh,
Sorry.
okay. Any further discussion on this, or is it accurate to say we have a split and thus no consensus to recommend a change?
It's actually a recommendation against, it's not a split, 6-5. 550 is a split, right? Just hypertext.
Sure.
Thanks, Steve.
Well, doesn't Dave get a vote in a tie?
It goes to an arm wrestle.
I'm sorry.
actually.
Let's get stuff of it. Just kidding. All right, the next topic is education and training, and the potential recommendation was to require the board to provide directly or through a CME vendor or entity for continuing ed and training on key topics within a specialty and is related specifically to workers' compensation. This came relatively, pretty close to consensus, 9 in agreement, 1 disagreement, 1 no response. The 1 disagreement stated, I disagree with the idea of imposing the additional training because of the risk it's going to exacerbate that shortage. The recommendation itself didn't say that the training was mandatory. That's certainly something that could be recommended, but, so I don't know if that changes that disagreement position.
Yes, that changes my vote. I agree. That's consensus.
So it's optional.
Well, I want to, hold
But
on, the medical society agrees, the medical society agreed provided physicians be paid to attend the education. To have the burden placed on them, time away from their practice, their family, their lives.
Who's paying?
But it's not mandatory.
I thought I was
Well,
the
we
dissenter.
didn't.
So if it's not mandatory, why are we gonna do it?
No, no, no.
I mean, let's
don't think we've
let's not
determined-
fish for things to recommend here. If we're gonna make a difference here, I think that they should do it. Or maybe they should get dinged for not doing it. The judges should be able to give their reports less probative value, something like that. But to set up this voluntary system, the folks who we wanna get at are not gonna go. Right, the people who are behaving badly in the system are not going to participate. I didn't realize that this was going to be a voluntary piece. I thought it was a mandatory continuing education.
We didn't indicate either way.
Right.
We didn't indicate that it was mandatory, I just
Right.
wanted to
We
point that
didn't
out. But the
indicate that.
board can and does require from time to time that certain trainings be taken, like we did with the 2018 schedule guidelines. And that's certainly something that's within our authority, and it could be recommended by the committee.
Yes, Mindy.
I actually think it's a good recommendation. Dr. Goldberg's point is well taken. I made this suggestion previously, and I think to ask somebody to take they do these, I said, we do these all the time at work, where you have to take a training in EEO issues or whatever. You do it at your desk. I think if the board were to create some sort of a training mechanism, it was done at on your desktop or on your laptop. It takes, we don't have to mandate exactly the amount of time, just to remind people how to do a comprehensive IME, what the parameters should be, what they should be looking at, how to fill the form. If it was a half an hour or a 45-minute, instructive video where you have to answer the questions, after every section, I think that would be great. I don't think it's a huge imposition on the doctors. And then I think you have a confidence that everybody's been trained and they're trained in the same way and they're taking the same approach to the IME.
Mindy, please do not volunteer the time from somebody else. Those individuals that are sitting at the workstations in your office are being paid their salary while they're there. That's not so when one mandates another person to sit for it.
If you think 45 minutes of your time, you have spent hours here at these meetings, and I don't understand. I think 45 minutes to help ensure that everybody's trying to do the same thing the right way. I don't think it's a huge undertaking, and I'm not volunteering your time. You don't want to do it, don't do it.
I think the same way we did the 2018 mandatory training, where we did get CME credits, was reasonable, and the doctors who don't want to do IME exams don't have to do it. But it should be limited. My recommendation was 2 hours every 2 years as a maximum, and give CME credits for doing this. All the doctors are required to do CMEs to maintain our board certification. So I think free CMEs is nice, and I just don't know if there's money in the system to pay doctors to do it. But if there is, I think you should pay us.
I think that's a really reasonable, except the last part. That was reasonable up until the end.
You were doing okay until that.
I think that makes sense.
So mandatory training, 2 hours
Limited to
every
2
2
hours every
years.
2 years.
No, it was voluntary, Mary Beth, because when
Well-
it's mandatory, we should be paid for our time.
Well,
I
think
don't, if the fact that I'm here and volunteer my time is a personal decision that I make.
You're getting
Because
free
I
CME
feel
credit.
how important this is. But the savings that are gonna redound to the system should be shared with the physician that you're mandating to attend.
Does the
So
CME,
they
does the
should be
C,
paid.
does the
Otherwise,
CME credit have
disagree.
value, though?
I think
Does
we're
the
saying we'll
CME
make it
credit have value,
CME
Doctor?
credit available, so that you have to take a certain number of CMEs per year anyway, so we would make sure our training was CME eligible.
That would be the compensation. The CME credit, does that?
Does that change your decision?
Yeah.
No, it influences it, but I have to get back to my team to see how they feel about it. We felt very strongly that if you are taking time, and it's going to be certainly more than an hour, just look at the amount of technical difficulty we had signing on today with really qualified people. These always go down when you're doing them. You never get in. You start from the beginning all over. You may not agree with the answer. These are not simple modules. We all go through them for different reasons, and they never go as planned. But again, we should be paid for our time.
So while you're checking with your constituency, is this something, Maribeth, that we could like recirculate this question as sort of restated by the committee and get people's reaction?
Of course.
Between now and the next meeting? So we could do
Can I
that.
make a suggestion? I suspect the board has these trainings also. Is it possible to see a clip from one of them at the next meeting? So that, because I don't think the doctor is really envisioning what I'm suggesting.
Yes, I am. I've taken many of these modules, Mindy. I've written these modules. I was a former dean of a medical school, and I had students take modules for everything. I'm quite familiar with how different modules, from anything from sexual harassment to biochemical pathways.
Okay.
I would just suggest whatever the committee ultimately does agree upon, if there is to be training, mandatory or voluntary, I do feel strongly it should be conducted by the board and not farmed to any outside agency to formulate or to implement.
Yeah, I mean, we actually.
I second that.
I think that we have posted, in the past we've posted training with CME credits on our website. I think we expect to take our CME trainings that we did as part of our summer conferences and put those on the website. So it's really something that we do in normal course of business. And I think the goal would be that it would be sitting on our website, you'd be able to link into it, take your hour training, get your certificate, and be done. So that was what I think our goal would be. We would make sure we had the CME, we'd have to work with Mizzy to get the CME credits. But I think that, we would own that.
So we'll resubmit this out for a comment by the committee on the question of board promulgated 2 hours of training every 2 years for CME credit, and see what if consensus can be reached. All right. So, next subject is examination and reporting requirements. First, the timing of the notice for exam filing and service requirements. And number one is the ending of the same day, same manner. So that's, the same day, same manner is mandated in section 137. The potential recommendation is to allow the IME practitioner basically to use, or the entity to upload it electronically so that the board could have it basically immediately, and the other parties could be served in differing manners, by paper to the claimant and via electronic means for everyone else. There wasn't universal consensus on this. 8 in favor, 2 disagreed. I don't know if this is something that folks wish to discuss here. This certainly is something that, again, administratively, particularly in advance of hearings, for example, having the exam immediately available in CIS, which then obviously it's an e-case as well, does have some advantages for judges. So, that's the board's interest as well. But I didn't know if folks wanted to discuss, particularly on the disagree side.
So I'm one of the people who disagreed with all of these. I remain open to conversations on it. I don't know that here and now would be the most productive use of our time to have those conversations.
And the medical society is anxious to see how the portal is going to work, because it may solve these issues. So we had no opinion for 3 of them.
And I, like Joe had mentioned, that I'm opposed to it, but open to discussion and following up on that, even if we could get some more information as to what the potential portal would look like. And I would ask that if this is to be implemented, that the attorneys be permitted a paper copy, or at least the option of having one. Well, that's that.
So I think that obviously we can adjust the recommendation if we want to talk about like specific things like that the attorneys will get a paper copy. We certainly.
Or have the option, excuse me, have the option, perhaps could be the way to do it.
Yeah, you
Right,
can opt
right.
into getting it maybe.
So I do think that the portal is something that might be helpful for people to see. We could maybe have, I think Steve has a little bit of like a screenshot presentation of kind of how that will work and what it will look like. So maybe we can ask him to come to the next meeting prepared to at least give you the screenshots and give you kind of a flavor of how that's going to work, so that you'll have a little bit of insight as we move forward.
That'd be
So we'll put that
wonderful.
down as a to-do.
Wonderful.
So let's just say that's being held open for now.
Okay. I'll go to number 2, the notice waiver allowable option. So this would allow claimants to waive that 7-day notice if desired in any case. Currently, by regulation, it can be waived, excuse me, in C4 auth cases only, to shorten that notice, but not for any other cases. So same vote, 8-2 with 1 non-response. And again, with all, no need to repeat anything that was just said, but if anybody wants to discuss, certainly can, since we're relatively near consensus. But Justin, same on your end, willing to discuss, but not right now?
Yes.
Okay.
And I would love to see just that presentation that was suggested. That would do a ton to educate the final decision.
Okay.
Could we revisit this whole section after we see the demonstration, because we may be in consensus at that point?
I like that idea, because there are a couple others that might be tied in as well.
So
fine.
all of them under section 3, we're saying.
Yes.
Okay.
Well, not
So one of the things that I-
wait, hold on. If everything under section 3 goes from the bottom of page 1 to almost the bottom of page 2, then no, because I have some things to discuss within the
So
body.
we'll say, so number 1, A1, we're gonna hold. We're gonna hold number 2, notice of waiver. What about the filing waiver?
Forgive me, I forget exactly what that.
So the filing waiver would be, so like the notice waiver, which goes to the 7-day
Oh.
notice, the filing waiver is the 10 days or 20-day filing requirements if desired. Yeah, but that was a 5-5, that wasn't near consensus. So,
Okay. Well, my caveat to either subsection 2 or 3 of 3A would be unrepresented claimants not allowed. Well, yeah, I'd like them to have an attorney if they're going to waive a notice requirement.
So if we tweak this to say that it's only when they're represented that they can file a
Yeah.
waiver, is that more?
Excluding pro se.
I can live with that.
that would be a change in the law on the 7-day notice?
137.
I mean, on the C4 auth notice waiver? On the reg, it would be a change in the reg. Because you can be an unrepresented claimant now and waive your, no, I'm just pointing it out.
Yes, sir.
No.
Absolutely.
So if we change this recommendation to say, to allow claimants to waive, allow represented claimants to waive the 10, 20-day filing requirements, if desired, in any case? Do we
And
have
I-
any kind of consensus on that?
I could live with them waiving the notice. Again, I just don't want it to be an uninformed decision. As long as I'm involved, there have been myriad times when the carrier has called me and said, we're up against it, we've got a hearing, will you waive the notice? And I say, yeah, let me send you an email right now, that way you have a confirmation in writing, done. I just want to protect my client.
Right, and in effect, what you're doing can't be done. But I mean, I understand why you're doing it, but it.
Sorry.
No, I'm just saying, no, I didn't.
Or did I take it back? I've never once done that. I thought about it
No,
once, but I didn't
all
actually do it.
All I meant is, this is what I mean. All I mean is the recommendation would be to allow that openly, such that, because if you do that now, you could still come back, or your client could come back and say, I'm, because the reg says I can't waive any of my rights, that was one of my rights, and since it wasn't carved out, I'm just saying, that's the whole point, is to codify what you're doing as an option.
I would love to see Mr. Mead's reaction if I walked into court and said, I'm not abiding by that email. Like, I
Of
guess
course, of course.
that's
Yeah.
more important to some than others, you're right.
So that, I understand, that's the motivating reason behind the recommendation.
For doing stuff like that.
Not a good list to be on when there's only a few of us.
So on the filing of the waiver, we're saying if we change this recommendation to allow unrepresented claimant, only to allow represented claimants to waive the 10, 20-day filing requirements if desired, we seem to have a consensus on that? Do you want to?
I'm not there.
Oh, you're not there?
Okay.
Okay.
All right.
Okay.
So we're talking about the 1020
No.
filing?
No.
Well, both, the first was the notice.
I was
We
not
talked
talking
about that for representative claimant, and then we had just begun, but hadn't really talked about the 1020 yet,
Yeah,
which is
that-
5-5.
Okay, and that's the one where I have a distinctly different opinion. So my opinion and/or tacit agreement was for notice and filing waiver by the claimant represented only. Whatever the committee may feel, I have a much different response about the text.
So we don't have consensus because Joe's not there yet, right?
Yeah,
Okay.
yeah, right.
Okay.
So, yeah, no consensus on that filing waiver. And then number 4 was the proposed modification of the 1020 filing requirement by case type. So, for example, to split between a C4 auth exam, treatment exam, permanency exam, versus a carrier-initiated further causally related disability exam that'll end up being attached to an RFA2. In other words, to leave that timing within the control of the carrier, since if the carrier delays in filing that, it doesn't hurt the claimant because the benefits continue. But again, the idea is to try to alleviate some of the time pressure in a subset of cases. This would, that's where the idea comes from. And there's not consensus on this, 7 in favor, 4 disagreed. And my thought is that we're not going to get to consensus, but certainly I open it for discussion.
Is there any room with those that disagreed?
Can I ask,
Yeah.
like for a schedule loss of use, would you be willing to, let go of those 10/20 regulatory filing dates for that, where this claimant is back to work and we urged this, is there any urgency there?
Is that the
Or-
only one you want, just the schedule loss of use, and then nix on the rest of them? No way, no how, no chance?
My thought was even also for, anything was, if it's FCRD, again, I'm just curious as to the rationale.
We did this before. It's only non-prejudicial if the claimant is being paid benefits and not within the voluntary auspices of the carrier's generosity.
Oh, so under those circumstances,
But how finally are we going to parse this? And I don't even like the way this line is phrased, because it's kind of an all or nothing, and it says by case type, but doesn't really allow us any further room. Certainly, we can flesh that out.
Yeah, I think the thought is the committee would flesh it out.
in other words, where there's no prejudice to a delay with the claimant, really no, I'm not talking about certainly not treatment issues. But if the claimant is being paid, let's say the claimant's being paid a total, it doesn't help the claimant if you rush to get if an IME is delayed, no downside to the claimant, really.
Who decides whether it's prejudicial or not? Is that me or you?
Well, I think
No, that's a fair question, and
No,
a
I
very
would-
earnest one at that.
Yeah, no,
Do I get to say, no, you don't get to do it, or do you get to say, in my judgment, I don't think this is prejudicial, because we may have very different opinions when it
Can I weigh in on that? Just because I think this is the answer. I can't remember exactly how many types of IMEs there are, but it's something like 6 or 7.
Okay.
So the thought is to go and look at those that are directed by the law judge or the board, or initiated through a process that started with the claimant having a medical, like let's say permanency or scheduled loss of use. If it's in those circumstances, the timing is prescribed, and any delay would potentially delay those benefits flowing to the claimant. But there are situations, again, like that FCRD that is, the motion to suspend or reduce, that's, the delay in there is not prejudicial. So that's I think the way I was looking at it, if the committee wanted to go forward, is you break it down by that case type and who initiated.
I don't know what an FCRD is.
Further causally related disability.
Sorry, that's
about
one of
that.
our little abbreviations.
It may be, but the medical, as an individual, I'm concerned with looking at all of them together, because some will interfere with the access of a patient to get medically necessary treatment in a timely fashion. And I think those should go ahead. So to say that to permit it as a blanket, I believe will compromise the rights and privileges of others.
What if the claimant can waive this too?
It's not a blanket, though. I think that that was the point, that they were trying to say, we don't think a blanket makes sense. Potentially, there are certain categories, though, that might make sense. So that's kind of the discussion of what are the categories that it might make sense, if any.
That
So
waiver is
you want
that
to
previous,
circulate,
that's
if you
that
want to
previous
recirculate this one,
proposal.
identifying
Number
those,
three.
we'll
Allow the
look
clinic
at
to
it.
waive.
David, the suggestion
I
was if
apologize.
we wanted, if we wanted to recirculate this one with that, those identified, those that may inherently would not be prejudicial.
Well, I don't think we've gotten to the point
Well,
where we even
we
have
haven't,
that
I just wanted to
locked
say,
down.
I think that it would be up to the committee to make that determination, but there's one possible approach is to list those types of IMEs, who initiated them, and use that as a basis to make that decision. And we could certainly circulate that,
Yeah, let's do
and have the
that.
committee react to that.
Would that be helpful, Doctor? Yeah.
Yes, thank you.
Okay. And then the last, in this subsection, was the modified request for information form. This is the IME 3 form. So this would allow the practitioner to send the request for information and its response together with the IME 4. In other words, bake it into the IME 4 as opposed to being a separate form. That's one of the complaints that we had heard from the medical community particularly, is that this is onerous, extra paperwork, and the content of it could be fully baked into the IME 4. The vote on that was 7 liked the idea and 2 did not. So again, I don't know if we could reach consensus on this, but certainly throw it open for discussion if desired.
My major concern, and I would ask those versed in this to speak on it if possible, is what do you do about the IME 3 in its purest form, where it's just a true addendum and a request for information after the fact that may come weeks or months? If we're just eliminating the IME 3 as the vehicle for request for information, or modifying it to say that that's not, well, then I wouldn't know what we would do about that.
Can I don't want to
No,
speak
please.
before the committee
Before we
speaks.
go further, can I just ask, would you need statutory authority to do this?
Yeah, we would need to change the statute, yes.
Okay.
But I think that, there's a couple of possible approaches. I totally understand your point. One would be to carve out the initiation of the addendum. Because, the first thing that you're going to see on an IME post-notice is going to be the IME report. But I understand what you're saying about people needing to understand if there's an addendum coming. So we could split out the rule and have it be an IME 3A, just for addenda. That's one possibility. The other is, you could also bake it into the addendum report. But I understand that doesn't solve the problem you're raising. But there's nothing that says that you couldn't split out those two.
Could you do it by
Those two types.
By time, which is to say that, if the additional inquiry comes within 20 days of the initial examination, it may be folded into or that doesn't solve the problem, does it?
Right.
Okay.
When I read
No, I
this one,
can't. I can
this
explain what
reminded me
everyone
of-
else. I'm sorry.
reading this reminded me of algebra in high school, where they would give you a proof at the end of it, and it would say, so it follows, it comes to this next line, and I never knew how they got to the next one. So here, when we have the response to the RFI together with the filed IME4, thus eliminating the separate, well, that's not always true. It's not true because you may be asked to do an IME, and you're given very limited records up front. And there are times when, as an individual, I refuse to do an IME without having a larger battery of information in front of us. In that case, the IME 3 is necessary, because I would not want to examine somebody and put that person at a disadvantage because they don't have enough information. So I would say and or, not thus eliminating. I think it should still be preserved, that both avenues should be available to the physician.
Okay.
Excuse me. Can somebody explain to me, please? I don't understand the problem. What does the IME 3 accomplish other than being clear about what additional information is being provided to the doctor.
It accomplishes making sure that I, as counsel, know precisely what's being posed to the doctor and in what form, just as I was entitled to vis-à-vis the original IME-4 and any questionnaire that may have been attached thereto.
And it also prevents, and it also controls bias on the part of the physician who may at front know that records are being either not provided or being withheld.
So you don't really want a form titled response to a request for information. You want notice of a request for information.
Or what I was going to say is I could see, and I think what the reg says now, forgive me if I'm mistaken, is that the doctor, upon receipt of the request, needs to send that with an IME-3, and then within a certain amount of time must send the actual response with another IME-3.
Correct.
I could certainly live with just getting them all at once. So as long as I get the questionnaire at some point, it eliminates the doctor doing it twice. You send a letter to them, say, I don't understand this, this is what I'd like, or you didn't talk about whether the arthroscopy would be necessary. Doctor sends one copy back, IME-3, this was the letter I got, and this is my response.
Yeah.
And I don't care if you upload.
Now,
Well, we'll see about that. But
when the IME was born, IME-3 was born, it included all of the records that the IME was asked to review. So we got huge volumes of duplicate documents in the board file. The board corrected that problem by penalizing anyone who put a duplicate document into the file.
But wait, by also
So-
saying you didn't have to submit them again, right? That if they were in there, you didn't have to resubmit them, just documents?
Sure.
Okay.
Sure. So I come back to, I think that the IME-3 as currently drawn has outlived its usefulness. I think you're actually asking for something else, which, I mean, you're entitled to notice of the exam. You should also be entitled to notice of the questions that the doctor's being asked, including if there are follow-up questions. Now, and that doesn't necessarily need to be on a form, although we seem to like forms. But it's not the IME-3.
No, and if the merit or substance of it was regulatorily required without necessarily, I mean, I'm not wedded to the form itself, just the result.
Parenthetically, I always thought they were numbered wrong, because the IME-5 comes out first, and that's the highest number. The IME-4 comes out last, and that's the middle number.
Yeah, you're right.
You don't have to change everything today.
Well, if I may, it sounds like, it's different than this potential recommendation, but the concept of keeping the IME-3 and getting both the request and the response at the same time, as Justin suggested, is that something that folks want to consider between now and the next meeting? If we send that out?
Sure.
Well, this kind of falls into this kind of merges for me with the discussion of the IME-5A. And, before Justin proposed that, one of the things that I was thinking is that it's a requirement that any questionnaire to be used by the IME be disclosed in advance to the claimant and the claimant's attorney, gives the claimant's attorney an opportunity to prepare the client for the examination. The same is true with the questions. So it seems to me that the claimant's attorney, I'm going to lose my cred as a defense lawyer here by saying this, but it seems to me that the claimant's attorney ought to have advance notice of the questions to be asked. Am I wrong about that?
No.
Joe, you disagree with that?
There's a little crosstalk here, I totally missed it.
Oh, well.
They were talking trash about us, I know.
It wasn't important.
This is another one, though, that I am open to discussing, but I'm not in a position to agree now.
All right, so I think we'll send that as a follow-up question. We'll just see kind of what the reaction is to it on the question of doing both the request and the response at the same time. All right.
Okay, so the next set of questions is on the volume of IME forms, as we started to talk a little bit about in that last question. The question on changing the IME 4s and the proposed changes, and I think it's interesting because it seems to me that most people think that the IME forms need to be changed. I think we can almost get the consensus on that. I do think that the idea of going to potentially a modernized online electronic filing process seems to be somewhat desirable, although I'm sure there are aspects of it as far as like giving people, maybe the injured worker the copy of the reports in hard copy. But go ahead.
Are you discussing point number 2 of the subsection?
Well, the first one is just saying change the form. So there seems to be 7 people say yes, change the form.
And that's where I'd like to slide my little point in here, if that would be permissible to everyone.
Of course, yeah.
Okay, so I suggested a new form. In the last meeting, unfortunately, Mr. Mead was not here, but we had discussed the idea of the IME questionnaires, and we utilized a couple examples of those which were unduly onerous and lengthy to the point that they rivaled the most recent application I filed for life insurance, essentially. Not everyone here agreed, but there seemed to be a general consensus that there was no reason that a form for an IME should be that complicated or that difficult or that much of a tool to be potentially misunderstood or utilized as a litigation sword as opposed to simply an aspect of the case. A couple people, I think Joe and I, were in favor of eliminating the questionnaire entirely. I'm not going to speak, or any ability of any IME to do that. I'm not going to speak for Joe today, of course. The physicians who were present at the meeting seemed to suggest that there were benefits to them having a questionnaire, but, and again, I do not mean to put words in anyone's mouth, but that it certainly did not need to be that onerous or that difficult. I proposed a form and a modified regulation, which does not seem absurd, but it is simpler, it's clearer, it's more reasonable. It comes with uniformity and a notice requirement, which removes almost all possible objections from the claimant's bar. And it doesn't prohibit any IME doctor from asking any question that they feel is relevant at any time. You want to ask my client about past medical history, by all means. But my purpose in leaving that off of this particular form is so that it would absolutely mandate that that question, which is undoubtedly the most troublesome one for our purposes, must be the subject of some, at least limited, verbal interaction between my client and the doctor. Have you had a past injury before? What do you mean? This body site? Another body site? Do you mean any condition? Do you mean any treatment? I've been on both sides of this, and unfortunately, even without carriers necessarily having any untoward objective at all, there is always going to be some young whippersnapper attorney that's going to look at a form and say, well, the client put this down and that's not right and he must have meant to lie, and so I'm raising 114A. I can honestly say now, having seen both sides, that not all of those are genuine cases of fraud or intent to deceive by the injured worker. And so given that there's at least a general consensus as to the change IME forms, and that I have brought this up in the past, I am positing the suggestion and the form as something that I would ask the committee to consider suggesting in some permutation close to this that the board adopt and regulate accordingly. It seems that there are at least 7 people that are okay generally, and based on my recollection of the last discussion, even more particularly with respect to the issue I brought up about the IME. But that's what I'll say for today, and that's my ask of the committee. Unless someone feels that medically speaking, not in a litigation sense, but medically speaking, and I defer to the doctors more than anyone respectfully, that something is missing from this form that would make it dramatically more difficult for a medical examination and a proper one to take place. But otherwise, I'd ask that the committee consider adopting this form.
You're right that I wasn't here last time, but I watched you all on TV, and it's a good-looking group. But my only concern with your proposed form is I'd like to hear what Dr. Weinstein has to say about it, because I recall that I recall that he said he has a form that he uses before IMEs and that it's a valuable tool.
I recall as well. fact, and not to be at all odd, but the doctor, I think, had suggested maybe getting us a copy if possible, just for review, but.
Right.
You know,
So I brought the form with me. I didn't send it out because it's just the form that I use. I don't know if I can hold it up to the camera if people just want to see it. Would that be helpful?
Can you read us the questions?
Yeah, I guess I could do it that way. Actually, let me hold it up. Tell me if you guys can see us. I'll hold it by the camera.
Or even if you would be so kind at some point to make a bit of a comparative analysis, if you feel I've left pertinent questions.
Yep.
Closer.
It's like a mugshot.
It's a mugshot, right?
Yeah.
It'll get blurred.
No? Okay.
No.
All right, rather than to take the time and guess what they say, can we please circulate those 3 forms? The existing one, Dr. Weinstein's, and the one that you sent out earlier?
Yeah, so I'll get this out to everyone, but it's how were you injured? It's very open, so it's nothing restrictive, but it's not anything that I consider that it'd be hard for them to answer or difficult, except if they're not speaking English. And it's helpful for me. It's more of a guideline than an actual form that I work off of, but it's a guideline for me to go through it with them after they fill it out. So it's just to expedite the examination. So
Given the variety of the forms and the fact that the Medical Society believes there are way too many forms, which is one of the reasons why physicians don't want to participate, we'd like to see them, but we feel the use of them should be at the discretion of the physician.
I agree 100%. I think this form should work as a guideline, but everyone should be up to their own mechanism of doing exams and getting histories.
Okay, that unfortunately does not solve any part of the current problem, but I accept that statement.
So that, are we back to modernizing the forms electronically, but no real changes to the forms, except potentially rolling the additional information in at the end?
No.
My take on these is that they should be prohibited. These are interrogatories presented to injured workers outside of the presence of counsel. Might be able to consider something if they're provided to their counsel, or there was a prohibition on them being used in the hearing in an attempt to impeach the credibility of an injured worker.
And we believe they're important because they allow us to understand what is the current nature of the patient's complaint, what are the limitations, if any, they might have, what they may be treating with. In addition to being treated by workers' compensation authorized physicians, sometimes injured individuals go out elsewhere for care, and having an ability to ask these questions goes a long way.
Oh, but doctor always has the ability to ask whatever questions may want to be posed. I mean, there's no verbal limitation on any question that could ever be asked. There are times when I fairly believe that it should not be reduced so simply to writing unless there is some guarantee of that subsequent discussion and perhaps modification of what goes into the IME report. But I would at least want to know what important parts of the general medical questionnaire I left off of this one. This is not a form that a doctor would have to fill out, so concern is fairly placed, but somewhat irrelevant in terms of this. This is the carrier's burden. My claimant brings it with us. The only thing I could see as being a difficulty for the doctor is if there's a question that's not posed here that a doctor feels cannot be fleshed out verbally either, which would limit the ability to do a fair medical examination. But other than that, and again, let's just go back and say what Joe said last time, this is a trap. It's just a trap, and that's all it's used for. And if we can come up with something where it asks reasonable questions in a reasonably kind of vernacular, just a bare sense, that's fine. But I'm going to hold to that one.
Actually, first I want to congratulate you. Thank you so much for putting in the time and effort to create this form.
You can't possibly mean that, but I'll take it.
Why would you say that to
Only
me?
because you and I have, we've, I think, first agreed right now.
Don't you think that's like rude?
No, I didn't. I was joking. I apologize. I meant
thank
it
you.
totally as...
A joke? Good. So I did mean it, actually. I was
Okay.
pretty impressed.
I thank you very much. And I did not mean anything untoward, truly.
I actually think you did a very nice job. I think you highlighted precisely what the issue is past history. And as far as the doctor wouldn't have to fill it in. I think having an IME questionnaire form from the board is actually helpful, because then claimant's counsel always has the form in front of him and can always prepare his client for an IME because he knows precisely what's on the questionnaire. So I thought that was really a plus.
Thank you. Forgive me.
But I would say, I do think it's important in general terms to have to know whether there have been prior injuries to the same body part, and also whether there are other conditions, significant conditions, which might impact the injury, the healing, the treatment, etc. So, having said that, otherwise, I thought this was a great attempt. Thank you.
Well, thank you. And again, was not to take away the carrier's right to due process. I started with Stockton, Barker, and Mead. I will never deny the carrier that, and that this should be a fair forum. Only that a lot of problems come from that there not being a verbal interchange with that question of past relevant history, past relevant disease that affects. Those are words that escape my client in every sense and lead to so much trouble. So I guess I would only ask that if people really don't like this form, they at least try to give some indication as to what they would want or need added to it for it to be acceptable. Again, the doctors don't have to fill this out. It's one less thing you have to do, actually, most likely. And, maybe you're not doing any part of the form, but then status quo. But I'm willing to table it to next time if that's necessary.
That's to give everyone a chance to take a look at it.
Can we do that and then also give people the opportunity to add anything they would add or take out whatever they would take out, so that we could perhaps get to something that we could get consensus on?
And please include Dr. Weinstein's form.
That would be fascinating.
Justin, could I just ask you one practical question on
Please.
the idea? So how do you envision it getting into the file? Is it something that, let's say it's filled out with counsel present or mailed to counsel and given back? Do you envision the claimant bringing it, like the original I'm talking about? 'Cause
Yeah.
it calls for an original signature, bringing that and then
Or doing it at the IME doctor.
The-
Why not?
I wrote, please complete, and bring a copy, bold, big bold, bring a copy of the questionnaire with you to the examination.
What if they don't?
And so the
And then it would
original,
be-
Then they have to do one in the lobby.
Then it would be incumbent on the IME or the IME entity to file it with the board?
Collect it.
Sure, but could file it with the IME4 in the same simplified
Yeah.
fashion as all of the information presently perhaps going to be consolidated under a simpler form.
The IME submits the questionnaire anyway with the IME form,
yeah.
so.
Mhm.
Yeah.
And in fact,
Yeah,
maybe
but
subject to
there's no,
preclusion.
but there's no danger of preclusion if the IME doesn't use a particular questionnaire. And I suspect that if this questionnaire is required, then if it's not included, I'm going to be responding to motions to preclude IME reports.
But you're probably doing that now, because doesn't the case law and regulations say if there's a questionnaire filled out, it must be included with the IME, or I can get it precluded anyway?
yes.
Okay.
I like the idea of the claimant filling it out at the time of the examination. My concern is if we give them a document, their lawyer will fill it out, and it won't necessarily be their statement, and it can also be pages and pages, and we already have a lot to review.
Okay.
So the document that I've come up with is one page, very simple, as a guideline for us to go through the history and exam. So, but I'll send it to everyone. I think we should table this for next week. It's getting late.
Yes, sir.
And when I look at what is in front of us, on the right-hand side, it says the IME form should be eliminated. I don't know who wrote this, but I like it. IME should be given access to all relevant medical reports in the board's possession. Is there anybody who disagrees with that?
Goodness, no.
That was me, I wrote that.
Thank you. Is there a reason, is there an argument against that? Because I'd like to see that happen.
Doesn't look like it, no.
No, but I
Especially
think
with this
it's,
comment.
as a practical matter, it's problematic, because are you gonna give
The entire
access to
record,
every,
yeah.
right, the entire record to the, in the ECF to the doctor? And is the doctor, does that help the doctor? Because the doctor's now gonna have, could have, you talk about a record, now you've got, could have hundreds of medicals to review. So I'm not so sure that that's going to be helpful to you, Doctor.
I believe it would.
And I don't know that it matters what area of law you practice in, if it has to do with injuries or compensatory anything. Every court has held that you can't use your medical history as both a sword and a shield. So I certainly would not say that a doctor could not review the medical records in the file, and certainly I'd be duty-bound, or the carrier could supply any additional that seem relevant to the ECF.
So can we have a recommendation that the physician be given access to the entire medical file from this committee?
I'm not there yet, but I'm willing to consider it.
I'd be willing to consider it in conjunction with questions to be considered at this next upcoming meeting.
Thank you all very much for that.
Yes, sir?
Well, I think, I just want to clarify that we just have to figure out the vehicle for that, because currently, we can't do that.
Because it would be the entire electronic case folder,
Right,
not just
we don't
medical.
have a tab for medical that we can allow just access to that particular, like, we could build that into the new design. I think that was the plan in the new design, quite frankly, to consider to allow them to have a unique view in. But today, if you give them access, they see everything, and I'm not
Okay.
sure that's what you want. So I think it's a fine recommendation, if that's the goal, we can drive to get there, but it wouldn't be something we could do like as of 1/1/2020. You know what I mean? I just want to make sure people understand the system limitations we have. But it's not that we can't say it has to happen, it's just, it can't be like immediately.
Would that
Well,
require
I
a
asked the
statutory-
question the first time in 1986, so I've been patient.
Would that require a statutory
I mean,
change?
yeah, he can wait as a party of interest, yes.
It might
It would
require
a
something about
regulatory-
110A.
It would require a regulatory change on the identification of party and a 110A change.
Okay. I mean, still, as a general proposition, I'd say more information is better, and it would not be proper for me to attempt to shield anything from the physician's eyes anyway.
So are we saying that we have consensus on that?
I'm
Looks like
saying
you
I-
have consensus, yeah.
I'm saying I am
Go for it,
99%
Justin.
there.
Just say it, go for it.
I'm 99% there.
So we'll
But I-
double check next time.
Yeah,
How's
that's
that?
all. I'd
Okay,
like to
so-
make sure that all of the minds around this table are.
Okay. Okay, so we'll revisit that at the next meeting. So I also have that we're gonna look at the two different forms, Dr. Weinstein's questionnaire and Justin, your form and modified regulations. And we'll figure out if we can kind of merge that and get some kind of consensus on that as well, on the IME side. Okay, I think next we're on the evidentiary. David?
Yep. So under evidentiary considerations and preclusion, the first suggestion potential is to provide greater discretion on the precludable issues. So this is the substantial compliance standard that's baked into the current regulation 300.2, that the IME must be in substantial compliance in order to avoid preclusion. And 8 are in favor of giving greater discretion, 2 are opposed. One of the comments in opposition states the case law essentially grants judges this is the authority now, but I just wanted to point out that when it comes to the 7-day notice, the 10 and 20 days to file, and same day, same manner, that any violations there are not considered to be substantial compliance. So I do think that, you know, if the committee is going to recommend greater discretion, it would have an effect, and it would codify exactly under what circumstances that discretion could be exercised. And, you know, typically, substantial compliance issues that we do find doesn't need to be precluded go into things like the service upon, you know, all of the doctors, and taking issues of if something really looks like an inadvertent situation involving the IME doctor that might lead to finding that it's still in substantial compliance, or sometimes failure on a copy of a document or a signature. That's something that substantial compliance could be exercised. But those timing and filing and service requirements are typically not subject of substantial compliance. So anyway, that's where the idea came from, but it's an 8-2 vote. Not sure if that means we could have consensus, or if the situation is we don't have consensus. So throw it open. All right, I'd
Going
say
once,
we
going
don't have
twice?
consensus.
Okay. Okay.
Okay. The next thing was the potential recommendation aimed at the number one timing and compliance issue when it comes to IMEs, which is that C4 auth, that 30 days from the C4 auth. And the thought had been to balance out a permission of a evidentiarily more acceptable records review, contrasted with failure to respond timely leads to a waiver of all defenses. Some of the disagreements included questions about that waiver of defenses and what it means vis-a-vis getting paid. Basically, you can have an order of the chair that goes out and still not have the doctor get paid. So that's what this is about, because causal relationship is not included in an order of the chair. It's only medical necessity. So this actually would provide a more of a guarantee of payment, because the carrier would be waiving causal relationship as a legal defense. So that's why, it was, that's why the recommendation was made the way it was. Anyway, it looks like there's no consensus, but I just wanted to describe it. 7 agree with the recommendation and 4 do disagree. Certainly be happy to throw it open for discussion, but again, it appears that there will not be consensus on this one. I know the chair doesn't have a gavel, but if she did, the gavel.
Get
Okay,
out.
going once, going
I do
twice.
have a gavel, it's in my office.
I know.
Feel
So-
free to hit any one of us with it. Sorry.
So moving to the videotaping, which was brought up a little bit earlier today, it looks like the recommendation about requiring the claimant to advise the examiner or the IME team or the carrier in advance of the exam that he or she intends to videotape, 7 agreed and 3 disagreed. So it does not look like we have any kind of consensus about the videotaping notification. Anybody disagree, want to raise other points, or disagree we have no consensus?
I disagree that we would agree.
No consensus.
There's no
No
consensus.
No consensus, okay. All right, moving on. And then the same thing with about requiring them to videotape. That was raised a little bit today in the context of, the questionnaire, doing a quality review of what transpired during the exam. Again, it seems to be a very kind of mixed consensus here. I don't think we're 4 versus 5, with 2 kind of not weighing in. So again, I don't think we have any consensus that we want to require videotaping. Agreed?
Wouldn't it be a good idea, though?
I said yes, but everyone else said no.
No, I said yes.
I also said
The
yes.
NFL can't get it right.
Who, I mean, is it that it's an administrative burden on the doctors?
No, I said,
No, because someone disagreed with this, and
Yeah,
now
but-
everyone's saying, well, I
Yeah,
didn't
the
think.
two comments here of
Okay.
where folks disagreed. So one says significant cost and complexity to the process, and maybe no added value, but those are the 2 comments.
Okay.
I don't seem so strong.
Anybody else that put in a disagree, want to weigh in on this?
The Medical Society put a very long discussion under number 1, which addresses this. It talks about giving both parties 7-day notice, and we feel very strongly against concealed or surreptitious recordings during that. They should be specifically prohibited with language to the same. When we talked about a vendor, again, it goes to costs. So I thank you for having the opportunity to express some of these. Please take a look at them. If you haven't seen them already, they apply here.
Okay. Any other comments on the videotaping? Looks
Just,
like we have no
just
consent.
one thing on the costs. I don't think we're gonna change any minds, but, this isn't 10 years ago where you'd have to necessarily pay a vendor to come in and videotape every IME. I have my entire house covered. I did it for $500.
As did I.
The age of expensive video recording is over, and I just don't think that it's a valid reason to not do it.
I think it would eliminate so many questions that we've discussed today. So many issues in terms of fraud, the length of the exam, how is it possible for a doctor to do so many exams? I just think it would go to, it would be tremendous addition to transparency.
I do as well, from both sides.
Do you think it would take the 1 to 5 IME providers, the people who do 1 to 5 exams, out of the system? Because that's where we have a lot of the volume, I mean, a lot of them do a small number, so that's the question, will that just be like, I'm out, then I'm not gonna do 5? Will we lose more providers? Again, I'm just playing devil's advocate. I think if the consensus you wanna do videotaping, it's easy enough to do. I just wanna think through the ripple effect of, like the MISNY folks saying that they have concerns about it, not just cost, but just the process of itself. I mean, I'm assuming the recommendation is that the provider, the IME doctor would be doing the videotaping.
That
as
would
the
have to be
official
set up
record.
in any location where they're doing.
Right,
Which could be
right.
multiple locations. Is it gonna be at the right angle to accurately capture what happens? I see potentials for.
Yeah, and if we want to do it, I just want to lock down some of those details about, what's to be expected, who's going to do it, do they have to store the file? There's just some logistical pieces that have to be thought through.
Authenticate.
Yeah.
Right.
How long?
And also, where do we start the recording? I'd like to see it start from the time they open the door to go into the office.
I understand.
Okay, so no consensus on that. This is a-
I love that.
We can body capture.
I told my client to take a selfie outside One Stop. They wouldn't give him the form.
Okay, so we're going to, for now, hold with no consensus on requiring the videotaping. Okay, the next topic we have are on fees. The first segment is the no-show and cancellations. So the question is, do we want to set a fee for the carrier to pay in the event of a no-show or claimant cancellation, either a standard fee or fee structure? It looks like 7 disagree, 3 agree. I'm not sure we're able to swing this to full consensus to make any recommendations on a specific fee.
It's just something that in so many instances, the carrier may not have control over what the claimant did. The claimant may have a perfectly legitimate reason for having to miss it. It just seems perilous.
Okay, so no consensus to do a mandatory fee for a no-show or cancellation. And then consequences, there was a question about specifying the regulation, the number of no-shows and/or the circumstances of no-shows that would warrant barring payments if the WCLJ finds that the refusal was unreasonable. So it looks like we had 5 disagree, 3 agree, and 3 with no response. So it doesn't look like we have any consensus on the consequences. Okay, anybody need to raise any comments or questions under that? Okay. The next piece that we raised is the idea of an overall fee schedule for IMEs. It looks like more than the majority is disagreeing with setting a fee schedule, and the recommendations are more about letting the market dictate what the fee should be for their particular IMEs.
So I just want to point out that the fee schedule exists.
It's by
May not be
report.
enforced, but it exists.
It's a BR code, though. It's by report. It's not an actual dollar amount.
So they would fill in whatever. So
Yeah,
in
so
regular office.
137.3B, right, says that they should be paid pursuant to the fee schedule.
And in the fee schedule, it's a BR code. It's by report code.
So there's no fee designated.
So there's no fee.
You
So the
decide.
board
Designated fee.
so the board, is the board prevented from doing this?
Well, that's what this question is. Should we set a fee schedule for those exams?
Is statutory change required?
No, it's regulatory.
I think they should be paid pursuant to the same fee schedule.
The argument against that is, how do you equate then a sprained wrist or a finger to a spinal cord patient with multiple rib fractures? You have a shoulder fracture and a below knee amputee. They're not the same. That's why the by report is appropriate.
I think there's no consensus on this.
Yeah, there's no consensus.
Okay,
No
so no
reason to fight
consensus.
over it.
And then the next one is, I think there's even less consensus, maybe there's almost consensus to not do it. The network-based fees. So if they're using a network administrator, we would have to establish set of fees. I think that seemed to be even more troublesome than just setting a fee schedule. Then moving on to the IME entities. I'll turn that back to David.
So the first recommendation potentially is for annual reporting that is specific. So right now, the regulation allows for the board to ask any question it wishes, but it doesn't specify annual reporting. So this would, the recommendation is to change the reg to mandate the data points that would be collected on it and when. And we go into cost, scheduling, volume, quality, geography, et cetera. And looks like we don't have consensus on this. 7 are in agreement with changing that reg, and 3 are opposed. Don't know if anyone wishes to discuss. Okay, polite silence taken as no consensus. And then the URAC requirement, less popular. 2 agreed to require entities to have URAC accreditation, 9 disagree, although a couple of the disagreements centered around not necessarily knowing that it particularly adds value as opposed to being vehemently opposed. But still, clearly no consensus there. And then the next section is going into fraud, and I think, basically, we're going to have this discussion next time, Mary Beth? Is that basically your understanding as well? So certainly, if anybody wants to go over any of the comments that were raised, we didn't make any potential recommendations because we hadn't yet heard from the Inspector General on this area, but again, we'll come back to it, but if anybody wants to address, they may.
And then the last topic is, well, there's a couple actually, the reasonable distance for an IME. We're saying everybody, for the most part, that responded agreed there should be a reasonable distance. I don't know that we have set, or is there any kind of ability to get to what is defined as a reasonable distance? I think intuitively it makes sense to say they should only have to go so far. The question is, what's the magic number for that? And is there like an upstate and downstate differential?
I mean, would we want to do it based on travel time? Understood that varies depending on lots of factors, but travel time probably makes the most sense, right? If you're living in Brooklyn and I am in the Bronx, it's only, 14 miles away, 13 miles away. It's gonna take you forever to get there. 30 miles upstate on a Tuesday at 2 in the afternoon, it's gonna take you 38 minutes to get there. So, that might be and the problem is when you use this stuff as a sword, obviously, but if people are reasonable, you can make a reasonable time travel requirement, and I think that makes as much sense as distance.
So my comments aren't provided on this screen. I guess they were consolidated someplace else, but I agree with Lev that distance isn't necessarily what we should be using to measure, just based on the amount of time it takes to travel downstate versus upstate, or even upstate if you're not near a highway entrance or exit, and you're on local back roads. I suggested, a graduated system whereby the carriers or the self-insured employers would have to take on more of the responsibility for arranging and paying for the travel based on the amount of time, and then if it was over a certain threshold, that the injured worker have the ability to opt to have the IME provider go to them.
And I know the Medical Society said 30 for minutes and distance, but today as an example, it took me 2.5 hours to get here when it would normally be about 1 hour and 10 because of the vagaries of public transportation. So do we rely on the MTA? Do we rely on a taxi cab, Uber, or what? So I agree with Mary Beth. I don't know where you set these road marks.
I made a suggestion based on what the CPLR says, which is the county of residence or any adjacent county or any county in which the claimant has sought medical treatment.
I think the last one's tough, but
If it's impossible based on upstate geography or otherwise to make that work, what?
Waivable.
I mean, the other thing is, this is another instance where, I think that we're dealing with different thresholds here. What a person is willing to do to get medically necessary care is much greater than what they should be expected to do in order to give the carrier or employer a tool to, challenge their case. I mean, they're, in my mind, apples and oranges.
I think we could probably come up with a reasonable standard if we worked on it, but probably, can we come back to it?
Yeah, so let's, so we look like we may have consensus on that, let's just ask the committee to each come back, think about it in the next month, we'll come back and discuss it, see if we have any sense of what reasonable looks like. Okay.
Did everyone get that? Thank you.
Got it.
Okay, so then the next one is the wait times for the IMEs. So regulate the wait times for an IME, assuming each worker arrives on time, providing specific time frames. So 7 agreed that we should have some kind of restriction on the wait time, 1 disagrees, and 3 had no responses. So I guess the question is, do we think we can get the consensus on requiring wait times to not exceed a certain threshold? And if so, what do we, same kind of question, what's a reasonable definition of a fair wait time? And what are the consequences if they exceed it?
I wrote 20 minutes, but I'm open to discussion on the exact time, with really the only, I don't know if you have to check with the desk before you left or whatever, but that there would be no negative repercussions so long as the claimant did not leave before they were supposed to. That, if a half hour crawls by or whatever we think, and the doctor says, yeah, wait, well, you're gonna reschedule it perhaps. We would have to do something then not of course, but perhaps about the time frame for submitting it if the claimant leaves, but now I'm getting into the weeds slightly.
Well, I feel that this one goes back to the missed appointment fee. How long are we to wait for an injured worker to come in to show for a scheduled exam? Do we allow, what kind of a window is permissible? In my office, I state 15 minutes. I send it in writing, and I have a confirmation from the plaintiff's or the injured worker's representative that they understand that. We recommend they come early. So because I do that on the upfront, I do the same on mine. That I cut my time off or I reduce my fee if I'm late for a private patient, and I am not late very often for IMEs. I know I'll be late next time. So I think the two of them really have to go together. If you're not going to give a no-show fee, be very careful with what you demand of a doctor to do on this side. But we felt that 1 hour is kind of reasonable.
1 hour to wait in the office?
1 hour, that things happen, physicians, yes, 1 hour to wait in the office, and if not, then the claimant may choose to leave and will not be penalized.
I thought not.
I'm still open to discussion. An hour seems like a long time. I wouldn't wait an hour for my own doctor, and that's not asking something to be taken away from me, or perhaps.
Really?
So is
'Cause
this
But
another?
yet, if that doctor had to go to the emergency room to treat your mother, you sure would.
You're
And we
right.
don't know what's going on. I assume you would. You may not want to sleep with your mother, but you don't know what it was.
And I'll agree with Mindy that I'm an upstate boy too, which I don't generally have to wait 2 hours for the doctor, thank goodness.
It's not uncommon. I go with my mother, 7:00 a.m. doctor's appointment, and if we're lucky, if we're out by 10, and we wait hours. So I don't think to me in the city, 2 hours is not it's a long wait, but it's not a crazy wait. So.
Well, I don't know that we jumped to the 2 necessarily.
That's why I think,
The one.
that's why I thought an hour was a pretty reasonable amount of time, actually.
So maybe this is another one we can ask people to think about for next. Like, it seems like we have maybe some
A few of
consensus
them.
on this, putting some framework around a reasonable wait time. Maybe you don't have a time yet, but think about that for next week. And what are the ramifications? So if they exceed the time, what is it we expect the injured worker to do? Just, go to the desk, tell them they're leaving,
I think they
how
should
do we
have to
track it?
reschedule, though.
That would make sense but it may be through a vendor that the doctor says, listen, I don't schedule mine, so go call them, tell them we didn't do it. It's my only thought
I
there.
don't know, I think
But
that
it can
there's
still be
some way
done.
to figure it out.
No, I don't.
I bet you somebody out there has data on national averages for wait times, and we might want to just
That's a good
get that
idea.
as a guidance, because we might all be way off.
We can take a look at that.
So,
And maybe my doctor is very poor and nobody wants to go to her, and that's why there's no one in the waiting
Or
room.
no, maybe she's just very prompt.
Okay.
I think she's a good doctor, don't worry.
She's not treating the psych.
It was the best the Caribbean had to offer.
Oh, indeed, straight from Grenada.
Okay, so I think that concludes our questionnaire. Yes, I'm sorry.
So can I bring up something that was within the purview of this questionnaire, and we got so involved in the conversation. I want to put out, and I know this could precipitate a long conversation, but maybe it's something we could think about for next time. Somebody, somebody gave me a suggestion or a thought, and it's extremely unformed at this point, but it's a completely different paradigm for IMEs, and I thought it might address several of the issues we've been dealing with. So I want to put it out there. If there's some follow-up, I could put something in writing perhaps. But what about the idea of having essentially IME companies create something along the model of an urgent care, so that the injured worker could just, if they have to go for an IME, they choose the one near them, they make their own appointment, they walk in and wait however long, if they want to wait, so that the randomness, it's no longer the employer choosing the particular doctor or IME company. Would be some value would there be any value in that sort of an idea? If it's directed by a judge, they have to go within, the judge says, within the next 3 weeks, or if there's a request by the employer. This is extremely unformed and not fleshed out at all, but it's just a thought of maybe, is there another way for us to look at this that might solve some of the problems that we're looking at? That's all, so.
That's interesting.
20 years ago, if somebody said urgent care centers would be a major player in the market, they would be laughed at, and I know doctors that were scoffed at. However, we could think about it once we have access to the entire medical file, because until that happens, how will they make that available to the physician? Are they going to send the record to 30 different IME offices, hoping that that person gets captured? And then once that happens, I can see one office getting that record and sending a van out there to pull up that patient and bring him in. So
No, well, what
it's an
about?
interesting idea, but once we have access to the file, I'd like to discuss it further.
But just to answer your question, it seems to me, I know that when I go to one doctor affiliated with one hospital, and then I go to another completely unrelated physician related, to Mount, also, attached to Mount Sinai, let's say, they all have access to the record. So I think that diffuses the issue you raise in terms of access to records, because whichever IME company, place, it's like the network, only it's not a network provided by the board. It would be a network sort of like diagnostic tests, where you say, if you're going for an IME, you get this choice of people to go to, or facilities, and you make your own appointments. So I just think that it's an idea worth considering, and maybe I don't know how I can help that along, but maybe people could think about it, and then we could discuss it again in the future.
Okay.
Point of clarification, one of the big problems that physicians have is that electronic medical records are not interoperable. So much so that that 2 years ago, if you were a patient at Montefiore in the Bronx, your radiology report taken at Montefiore would not be available to the floor. They had to be faxed over. So to think that you could be a patient at Sinai and get records from NYU or from Beekman downtown, that's not the reality.
No, but
yes,
if
it's
it's
something we're demanding, but it doesn't happen.
No, but if your IME vendor or IME company has those records, it could theoretically be available to every IME doctor within that network.
And what about the thousands that belong to no network is the question I would raise.
All right, well, something to think about. That's all I'm suggesting.
Thank you, Mindy.
Okay, so we have categorized the no consensus. We will start to write those up. The other ones that are still open, we'll kind of do a summary for everybody and send it out as a reminder of what's left on the table for our next meeting. I think at this point, we'll turn it back to Michelle.
Yes, and all of you have been given a draft report that essentially is the template. That looks like this.
May have taken the
I
one
don't know
that
that
was,
I
Here.
I think there
You
was
can have
one
mine.
for the two of
Yeah.
us.
Essentially, it kind of lays out the report
Just so.
and puts some, puts the structure there. Clearly, there's no recommendations written, there's no executive summary written, that we're still working on, but at least to let you see what the final report will potentially look like.
The layout anyway.
Right, the layout. So it'll include the intro, executive summary, methodology, summaries of the meetings, committee recommendations, and then all of the appendices. So by all means, you should take a look at that and we can discuss it next time. In the interim, to the extent possible, they're gonna start filling in the blanks because next month is October. And October, life tells me, is very quickly approaching December when the final report is due. So our next meeting is gonna be October 10th, here at 12, when we will review the next version of the draft report and, start to get your feedback and talk about the issues we kind of tabled today. We have been here a long time today, so safe travels back. See you next month.
Thank you.
Thank you.
Thank you all.